All rise.
The Kosovo Specialist Chambers is now in session.
Good morning and welcome, everyone. Madam Photographer, you may proceed. Madam Court Officer, you may call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
Now I would ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office.
Good morning, Your Honors. My name is Matt Holling, Associate Prosecutor. Appearing also with me on behalf of the SPO is Deputy Specialist Prosecutor Alex Whiting, Prosecutor Valeria Bellici, Associate Prosecutor James Posh, Case Manager Line Peterson, and Intern Francesca Girardi. Thank you.
Now turn to the defense, Mr. Reese.
Your Honor, my name is Jonathan Reese. I'm assisted today by Mr. Hugh Bowden and also by Miss Ellie Stevenson.
Thank you. Mr. Cadman, please.
Good morning, Your Honours. Toby Cadman for Mr. Gucati&Haradinaj. I'm assisted today by Mr. Carl Buckley, co-counsel, Miriam Boxberg, legal associate, and Zijwan Ku, case manager.
Thank you, Mr. Cadman. And now we'll turn to the registry. Thank you, Mr. Roche.
Good morning. Thank you, Your Honours. My name is Ralph Roach, Head of Judicial Services Division, together with the Registrar, Fidel Madonna. Thank you.
I also note that the accused have waived their right to be present at the hearing. And for the record, I am Charles Smith. I'm the presiding judge for this panel, and my colleague judges are from my left, Christophe Barta, to my right, Ganel Matro, and to my far right, Fergal Gaynor. Where's Vicky? Vicky, could I ask you to step up? Before we start, I'd like to recall that this trial panel was assigned to this case upon the transmission of the case file by the pretrial judge on July 16th. Pursuant to Rule 117, upon receipt of the case file, the trial panel must hold a trial preparation conference with the parties. To this end, on July 21st, the trial panel issued an order in which it requested written submissions on certain matters, convened this trial preparation conference and set out the agenda to be followed during this hearing. As for today's session, we will take a break around 11 a.m. We will resume at 11:30 until about 1 p.m. We will then take a lunch break and we'll be back in court around 2:30 in the afternoon, and we will adjourn the hearing for today at 4 p.m. And if need be, we will continue tomorrow. Just as an advance notice, and during the trial of this case, the hours in this court will be as follows. First session in the morning is from 9:30 until 11. Second session from 11:30 to 1300. Third session from 14:30 to 1600, and only if exceptionally needed, a last session from 16:30 until finished. Tomorrow we will start at 9:30 rather than 10 o'clock. I'd also like to remind everyone that a few rules must be observed at all times in order to make for an effective courtroom with an accurate record. Please remember the previous warnings you were given in relation to the use of your microphones. I'm not going to go over them at this time. Also, bear in mind the necessity of a good translation, which takes a bit of a delay sometimes. If you are in the courtroom, please rise to ask permission to speak. If you're participating, I don't think we have anybody participating video link, do we? I don't believe so. Okay. What is said in this hearing is transcribed in real time and will be reflected in a transcript available to the parties and to the public after the hearing. I also remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. We'll start today's hearing with follow-up questions on the written submissions that we have received. We will then continue with the issues set out to be discussed during the hearing, and questions may come from any of my colleagues. I ask you to please refrain from repeating yours or your colleagues' submissions, be that written or oral. I can tell you that we have read them all. And please remember the panel's instruction to limit your oral submissions to a total of 5 minutes per issue and to be concise and focused in your arguments. So we'll now start out with follow-up questions on the protective measures requested by the SPO. And I'm going to first give the floor to my colleague, Judge Barta.
Thank you. Can you hear me? Because I can't hear myself. Okay. Thank you, Judge Smith. As directed in the panel's 21st July order, the SPO filed on 23rd August a request for protective measures for its two witnesses. Given that this is the first application before this panel in respect of protective measures, we wish to ask some specific questions regarding the standard to be applied and the implications of the requested measures. The SPO requests the trial panel to authorize two protective measures for its two witnesses, namely, first, assigning pseudonyms throughout all public proceedings, and secondly, redacting the witness names and identifying information from the court's public records. The SPO submits that these two measures are consistent with the accused's rights and notes that the accused already know the witness identities and will have access to their complete testimony. The SPO further submits that these protective measures are necessary to ensure the safety of the two witnesses and of the persons they interact with, as well as the integrity of ongoing and future investigations. The SPO notes that the requested measures extend only to protecting identification by the broader public. In other words, the two witnesses identifiable by pseudonym will be seen and heard by the public when testifying. The Haradinaj defense responds that the requested measures amount to anonymity and as a result, Mr. Haradinaj is being denied the right to face his accuser, thereby being placed at a significant disadvantage which amounts to violation of the equality of arms principle. It further submits that there is no evidence to suggest that any employee of the SPO requires protection. The Gucati defense indicated that it wishes to respond orally during this conference. Mr. Rees, you have the floor to the letter.
Thank you, Your Honour. I'm conscious that full written submissions have been submitted on behalf of Mr. Haradinaj. I adopt those submissions, and I will adopt the submissions made orally in supplementary form today by Mr. Cadman.
Thank you, Mr. Rees. Mr. Cadman, do you want anything? Do you want to add anything at this point?
Your Honours, we have set out our position in written submissions, and I'm mindful of the direction not to repeat that. What we have set out deals with the question of anonymity. We recognise that the identity of those two witnesses are known to us. There are, of course, aspects of their evidence that deals with other witnesses who are not known to us and that we do not have the opportunity to cross-examine. The issue, of course, is whether all professional witnesses, as these two are on behalf of the prosecution, should be entitled to such anonymity. It is our position that there is no proper basis under the rules for granting the protective measures in the way that has been requested by the SPO. Your Honours, I don't want to labour the point. We've set out what our position is in written submissions. I'm happy to expand upon any point that is not clear or requires greater clarification. But that certainly is our position, is that under the applicable legal and regulatory framework, there's no basis for providing such protective measures to all professional witnesses from the Special Prosecutor's Office. But just to make the final point, Your Honour, before you interrupt, we do recognise that these are not anonymous witnesses in the strict sense of the meaning, because the identities are, of course, known to counsel, and counsel will have the opportunity to cross-examine them on that basis. But there are certain aspects of their evidence that will be dealing with anonymous witnesses that puts us at a significant disadvantage.
Go ahead.
Thank you, Mr. Cadman. We'll now give the floor again to Mr. Rees, please, in order to clarify whether you also agree with the statement of counsel for Mr. Haradinaj, that you recognise that the identities of both witnesses are also
I know the
known to you.
identities of the two witnesses,
Yeah.
absolutely.
Yeah.
But I nevertheless support the submissions made by Mr. Cadman in writing and orally.
Okay, thank you, Mr. Rees. I now give the floor to the prosecution. Mr. Prosecutor or Madam Prosecutor, do you want to add anything at this point?
Briefly, Your Honour, they are not anonymous within any sense of the word. As acknowledged by both defense counsel, they do know the identities of the witnesses. The Kostovsky case cited by the Haradinaj defense in their submissions is completely different facts from what we are alleging here. In Kostovsky, it was a situation where the applicant and the counsel were actually not heard at the moment in the trial where the witnesses were testifying and when their statements were taken. Nothing equivalent to that is happening here. There may be elements of unknown persons that are discussed in the testimony of these witnesses, but those persons are not within the scope of the protective measures request that we have filed. The protective measures request only concerns the two witnesses in question, and they are not anonymous. Thank you.
Thank you, Mr. Prosecutor. So my next question is also for the prosecution. In your request Mr. Prosecutor, you referred inter alia to Article 23 of the Law on Specialist Chambers and Specialist Prosecutor's Office, also on Rule 80 of the KC Rules of Procedure and Evidence, according to which protective measures can be ordered for the safety, physical and psychological well-being, dignity, and privacy of the witnesses and others, or of witnesses and others at risk on account of testimony given by witnesses, provided that such measures are consistent with the rights of the accused. Could you please, Mr. Prosecutor or Madam Prosecutor, clarify or specify why you are of the opinion that these conditions are met in relation to the two witnesses, especially how the safety, physical or psychological well-being, the dignity or privacy of each witness would be affected if their names were not redacted? If you consider it necessary to go into private or closed session before you answer, please let us know. You have the floor.
Thank you, Your Honor. I will try and answer the question in a way that we can stay in open session. As developed in our request, these witnesses have activities that, were their names to become known, would make it more difficult for them to conduct their activities, including their safety when conducting those activities. So the protective measures sought are in relation, in large part, to their ability to do their work with all requisite safety. As we mentioned in our request, they interact with other people. They are interacting with witnesses in our other cases. And because of that, anything that links their activities to their names is going to have a knockoff effect on other witnesses. What we are asking for is actually no more than what the practice direction calls for when referring to SPO staff in the course of proceedings. They are supposed to be referred to by their title rather than their name unless it's strictly necessary. And it's actually strictly necessary to keep their names out of the public record for the reasons that I was describing, and we don't feel like that there's any compromise of the rights of the accused, given that none of the protective measures will apply to their ability to examine the witnesses. Thank you.
Thank you, Mr. Prosecutor. To follow up on this, today, just a moment ago, and also in paragraph 4 of your request, Mr. Prosecutor, you claim that, I quote, ensuring that the two witnesses are only referred to by pseudonym is necessary for them to carry out their work while safeguarding their safety, the safety of witnesses and other persons they interact with, and the integrity of ongoing and future investigations, unquote. In this regard, I would like to know whether you argue, as you already did, that the work of the SPO in general and or the work of the two witnesses in particular and or the integrity of ongoing and future investigations are protected, specifically protected by Article 23, paragraph 1, and also rule of the law, and also Rule 80, paragraph 1, and if so, why?
The reason why it does is because the integrity of the investigations in this particular context is connected with the safety of the persons concerned. If our staff members are not safe when conducting their activities in the field, it is going to affect our investigations and the integrity thereof. So it's not a situation, and the defense makes this argument, that obstructing investigations is not in Rule 80, and therefore it can't be considered. In our view, that's not the way Rule 80 is structured. The reason why the integrity is affected is because of criteria that are in the rule. And as long as there are criteria within the rule that are applicable, the chamber can make a ruling on the basis of what is contained in the rule alone. And so it's all connected. There's not like a discrete factor that if it's not in the rule, you can't apply it. They are linked in this particular instance.
Thank you, Mr. Prosecutor. I would like to and Mr. Kedman.
Your Honour, just to respond very briefly to the points made by my learned friend for the prosecution.
Mr. Kedman, excuse me, you will have the opportunity to respond to everything after the questioning, if you don't mind. If you could wait just a few more questions or a few more minutes,
of course,
it would be nice. Thank you so much. Mr. Prosecutor, to continue, I would like to come back to per 4 of your request for protective measures, in which you say and argue that the necessity of protecting the identity of SPO staff members is explicitly acknowledged in the KC's statutory scheme. In this context, you mentioned inter alia Article 33 of the Registry Practice Direction on Files and Filings before the Kosovo Specialist Chambers that should require that SPO staff members shall only be referenced by their functional titles unless strictly necessary. If this is correct, Mr. Prosecutor, does that mean that, at least in theory, all SPO staff members can only be referenced by their functional titles and/or are entitled to pseudonyms during ongoing proceedings, regardless of their procedural role or internal function? Or where would you draw the line in this respect?
The line should be drawn where the practice direction draws the line, Your Honors. It is a general rule in the practice direction to only refer to them by functional titles. There is an exception built in when it is strictly necessary. If there is a situation where the name of an SPO staff member assumes fundamental importance for the fairness of the proceedings, for example, then it would be within the trial panel's discretion to declare that it's strictly necessary and that the names need to be revealed for procedural fairness reasons. There is nothing approaching that in this instance. We aren't asking for relief under the practice direction. We're merely pointing to the practice direction, as well as the regime governing standard redactions, that there are standard, understandable reasons why SPO staff shouldn't be named in proceedings. And those reasons are linked to Rule 80 of the rules, which is the framework governing protective measures. So we would never say it's an absolute rule that always has to apply in all circumstances, but there is logic behind these rules. The logic applies here as well, and there is no strict necessity identified by the defense, especially anonymity, which, as we addressed, isn't an issue, that would justify having to name them in this instance.
Thank you, Mr. Prosecutor. And now my last question at the moment for the prosecution. In footnote 7 of your request, you cited case law of the International Criminal Court, namely decisions in the trials against Dominique Ongwen, Jean-Pierre Bemba Gombo et al., and also Germain Katanga et al. Could you please specify why and to what extent the legal considerations of these decisions should be transferable to the present case?
Thank you, Your Honor. The ICC has a protective measures framework under, in particular, Rule 81 and of the ICC Rules of Procedure and Evidence. That framework bears a lot of similarities to Rule 80 of the KSC rules. So we are not saying that the trial panel is bound to follow the jurisprudence of the ICC, but we do note that these are cases where ICC judges have looked at similar situations and have granted in-court protective measures to prosecution investigators. In all of these instances, their identities were known to the defense when they were testifying, and there was no concerns about cross-examination. They got to take the transcript without redactions no differently than if the protective measures had not existed. It was a low level of protective measures that they were granted, and we are trying to follow suit with this application. If you compare our motion to our Rule 95 summaries for these witnesses, we're actually asking for less protection than we had previously indicated. We had indicated face and voice distortion, and now we are just asking for a pseudonym. So we really are trying to balance the publicity of the proceedings, and we appreciate that the trial panel wants to prioritize this, but we don't think that this is compromising the publicity of the proceedings or the rights of the accused for the reasons that we've stated, and these ICC cases reach the same conclusion.
Thank you, Mr. Prosecutor. This concludes my questions at the moment for the prosecution. I will now turn to the defense with questions. And of course, Mr. Catman, you have the opportunity, will get the opportunity to comment, and also you, Mr. Rees, or co-counsel, on what has been said by the prosecution. So my first question, or my question for the defense would be, or is, Mr. Catman, I will start with you because you filed written submissions. In your submissions in preparation for the trial preparation conference, you claimed that the measures requested by the SPO cannot be justified under the rules of this court, and further that they are not in any event consistent with the rights of the accused and his right to a public hearing, including the right to face those that accuse him. I refer to paragraph 11 of your submissions. Moreover, you repeatedly refer to both witnesses, SPO witnesses, as anonymous witnesses, a fact that in your view effectively prevents the defense from cross-examining them on the basis of their identity. Paragraph 18 of your submissions. Now, given that the names and also the professional background of the two witnesses have already been disclosed, to you and your client, as well as to the co-accused and his counsel, I refer in this respect to Annex 2, to the submission of the SPO pre-trial brief. For the record, this is filing number F00181/A02, and that the witnesses are to be seen and heard by both accused, their counsel, and also the public. Could you tell, Mr. Catman, the panel, please, if you still think that the measures could nevertheless be inconsistent with the rights of the accused, and that the defense would be effectively prevented from cross-examining them? Please note that we also read the Kostovsky decision you cited in paragraph 15 of footnote 10 of your submissions versus the Netherlands. In this decision, the European Court of Human Rights found a violation of Article 6, paragraph 1 and 3D of the European Convention on Human Rights, because the conviction is, in my opinion, correctly stated by the prosecution, the SPO, of the accused of armed robbery was to a decisive extent on the statements, based on the statements of two anonymous witnesses who were neither at trial nor during the investigation stage interviewed in the presence of the accused or his lawyer. But this would, as far as I understood it, obviously be not the case here if the SPO's request were to be granted. Mr. Catman, you have the floor.
First of all, it's accepted, as it has been earlier, that the situation is not strictly on point with Kostovsky. The names and the positions of the two witnesses are known to the defence. Of course, anonymity can be a broader concept in not just knowing the names of those individuals. What the SPO has referred to is relying on the general principles in the practice direction, in particular. Our position on this would be that the practice direction is guidance. It does not have a greater force of law than the legal framework of this institution. It is not accepted, and it has never been accepted by the defence, that there should be a blanket ban on using the name of any professional witness by the SPO. This has been raised by the defence in the past, that the practice direction, in our view, is not consistent with the general applicable principles. The issue is whether it is strictly necessary for the names of these two individuals to be anonymized for the purpose of these proceedings. As my learned friend for the prosecution has quite rightly stated, the initial application was for a greater form of protective measures, not just the redacting of the names, but there was two other forms that they were seeking that obviously the defence had opposed. They are now only seeking for the names of those individuals to be anonymised. The question has to be, why is that necessary? What the prosecutor has stated is that these are individuals who have conducted witness interviews and continue to do so. These are obviously individuals that are known. That has to be taken into account as to whether the fact that their identities are known as employees of the Special Prosecutor's Office and continue to be known in having contact with witnesses, why there is such a strict necessity for their names to be redacted. Again, not wishing to repeat what is set out in the written submissions, our position is first of all that it is not strictly necessary, that the Specialist Prosecutor has not identified why it is strictly necessary, what risk to professional witnesses would be incurred if their names were to be made public during these proceedings, and the fact that they continue to conduct and have contact with witnesses in a public form means that their identities are already known. So what I would submit is it is more of a question of why is it strictly necessary for their names to be redacted. Again, I must go back to the point that it is not just the withholding of an individual's names from the parties that goes to anonymity. There are limitations on our ability to effectively cross-examine witnesses if their identities are not known, and we are prevented by putting certain questions to them on the basis of their identity. That is what we're asking the trial panel to consider when it makes a decision of whether this application by the SPO is strictly necessary. We say it's not.
Thank you, Mr. Cadman. Mr. Rees, do you want to say anything on this?
If I may, I'll add this very short submission. It's a matter of principle. The starting point is that this trial will be a public trial, and the public are entitled to follow it. There is public interest in it, and they are entitled to hear from the witnesses, to know who the witnesses are, and to follow the evidence, unless there is very good reason to change that starting point position. Your Honour asked the SPO to spell out the nature of any threat and the evidence of it. It is, of course, a matter for your honours, but I struggle to follow a direct answer to that very straightforward and clear question asked by your honours. It's a matter of public principle. And we say that the SPO have not met the criteria, strict criteria, to interfere with the starting point, the general principle that these are public proceedings and the public should be able to follow them. That's my submission.
Thank you, Mr. Rees. Mr. Prosecutor, do you want to comment on this?
Your Honor, I believe that what we've said today in our application addresses all of the submissions just made, so unless the Chamber has any other questions, we have nothing further.
Thank you, Mr. Prosecutor. Those were my questions. Thank you, Judge Smith.
Any of my other colleagues have any questions? The floor is yours.
Thank you, Judge Smith, and good morning to all. I will start, if I may, with exploring the submissions of the prosecutor that the disclosure of the name and identity of the proposed two witnesses could create a risk to their safety and or that of individuals with whom they interact. I'd like to ask you a few questions about that. First, may I take it that when you discussed the possibility of these individuals being called as witnesses, you informed them in the exercise of diligence that they might have to testify without protective measures. Can we assume this to be the case?
You can, Your Honor. All witnesses that the SPO interacts with, it's always clear that protective measures are something that the SPO can request, but it is within the trial panel's prerogative as to whether or not it's being granted. So this was treated no differently.
And do not sit down, Mr. Halling. I have a few questions for you on this. But if that is indeed the case, and I'm grateful for your confirmation to that effect, that would suggest as well that when you ask them to prepare statements, 9 of them, for the purpose of these proceedings, you did so on the understanding that they might not be granted the measures that you are seeking. Am I right in that assumption?
Again, Your Honor, this is how it works with all of our witnesses. We need to take statements. We need to disclose them. It is not up to us whether they get protection. We can only say that we will request protection when justified. And again, it was the same here.
So again, maybe to state the obvious, but that assumes that you took the decision to call them, if necessary, without protective measures, despite the risk that you say there could be to them or to the individuals they interact with, correct?
That's correct, Your Honor. It's the risk that we run with all of our witnesses, even witnesses that have faced very grave security concerns and have had family members killed while testifying in proceedings. They still have to have their protective measures accepted by the chamber. It's always a risk that we run, but all we can do is make our showing as to why there's an objectively justifiable risk to them and proceed accordingly with the request for protective measures.
Thank you for that. I want to ask you more specifically about something you say. I think it's at paragraph 3 of your submissions that you refer to the risk to others, that the fact that their names or their identification features could effectively create a link with this organization that could put people at risk when and if they interact with them. What I want to know is, at the same time, you are not seeking, as you said properly, the non-disclosure of their physical appearance. And what I want to know is whether the disclosure of that physical appearance could potentially have the same associating effect between who they are, or what they look like, at least in their function, and how, in effect, you square the circle between asking us not to disclose their name while at the same time allowing for their face to appear on the screen.
Yes. Your Honor's question implicates the part of our motion that is confidential, but I will try and answer it in open session. There is an extra link that is created by the name of the staff member and their activities in the field, in a way that their face or voice alone may not. There is an extra ability to identify. There's an extra level of risk entailed by having their name, which can be determined on paper from all sorts of manner, and a name that has to be presented in the ordinary course just of travel in order to go on missions for the SPO, that risk is the risk that we are trying to address with our relief sought. If the trial panel concludes that the only way to address the risks is to add protective measures to our request, it's within the trial panel's prerogative. But in our assessment, we have tried to ask for the minimum that's required for the reason, to address the reasons that we state in our application.
Just to be clear, I'm not suggesting for you to ask more. I'm trying to figure out how one makes the other one logical. And just to take you on your answer, isn't the fact, you say there's an extra level of risk if the name rather than the face is disclosed, isn't it the case that more people will have or would have access to what they look like rather than have access to what their name is? I'm mindful, of course, of your submissions in writing that their passport might go into a number of hands for the purpose of their mission, but isn't that the case that there's a likelihood of more people being able to know who they are simply because their face would appear on the screen than having access to their passport?
There is some risk to that extent, but as I was saying, it is a lower risk. If someone took my picture, someone did take my picture in court this morning, and they took that picture and wanted to find out my name from the picture alone, how would they go about doing that? You can't put a picture into a Google search. There's an obstacle there to be able to identify someone from a picture alone. However, if you have my name, and not that I'm particularly everywhere on the internet, but it is much easier to identify who I am, where I live, what I'm doing, including pictures of me. The name is the thing that is creating a level of risk that justifies protective measures. And so although perhaps someone is able to make links of the kind that you describe on the basis of the picture alone, in our assessment, that risk is manageable. But the risk of the name is not. And so that's why we make the distinction.
Thank you. Now, it's the legal part of your brain that I want to go to Mr. Halling, if you allow me, and it's really about the application of the test that you are inviting us to exercise. If we understand it properly, the basis of your submission is that the disclosure of the identity of the proposed witnesses would create a real likelihood of danger or risk to the witness or to the individual concerned. Now, what I wanted to know from you is whether you were aware of any precedent, legal precedent from Kosovo specifically, that would have granted the sort of protective measures that you are now seeking from us, in particular having a police officer or a serving prosecutor who acts on behalf of one of the parties to testify in under protective measures, and if you are aware of such a precedent, would be very grateful for an indication to that effect.
Your Honor, we don't have any Kosovo cases exactly conforming to the fact pattern that you describe. There are European Court of Human Rights cases, some of which are mentioned on our list of authorities and in our bar table request, whereby no violation of Article 6 of the ECHR was found by police officers not being identified in the course of trial. So to the extent that Kosovo has to be consistent with the European Court of Human Rights, those cases can stand for the proposition that there is at least no human rights constitutional restriction in Kosovo to applying protective measures of the kind we are discussing.
Thank you. There was, maybe I was slightly unfair. It's probably a legal and factual issues, but what is important here is, of course, and you are right to point it out, the context that we are dealing with. And we carried out the small exercise of looking at cases from Kosovo at the ICTY, the Gucati&Haradinaj case, to try to identify precedent that might be relevant to those cases, and couldn't. It appears that those precedents suggest that in both of these cases, at least, each and all of the witnesses who served either in the past or at the time of their testimony did so in public with their name disclosed. Is that a correct assumption and understanding of these cases?
Your Honor, that is our understanding. However, the investigators in those ICTY cases were not repeat actors in Kosovo the way that SPO investigators are. Because of the way our mandate is designed, our investigators are going to go to Kosovo specifically far more often than an ICTY investigator who may only be there for a very isolated part of their broader responsibilities. And the way in which the risk is assessed, it has to be individualized, and it has to be indexed to the risks as of this moment. We have a footnote to our filing in the Thaci et al. Case identifying the climate of witness intimidation in Kosovo recently and what is the level of risk that is there in Kosovo now. And we would just ask that our application be evaluated on its individualized merits, what these particular staff members are doing now and the place that they are going to now.
I have just, you forced me to ask additional questions in response to my colleague Judge Barte's question that I want to ask you. referred to the practice direction both in your written submissions and again today in court. What I want to know from you, or maybe the first question is, of course the practice direction does not regulate the question of witnesses, right?
Correct. We do not ask the trial panel to make a ruling on protective measures pursuant to the practice direction. We want the ruling to be pursuant to Rule 80, and how to interpret Rule 80, we are making reference to other parts of the broader statutory scheme.
Because in fact the practice direction refers to the general mandate and competence of the registry to regulate the business of the registry, not the business of court, right?
Correct, Your Honor.
And to the extent that this practice direction would be relevant at all to these proceedings, of course, they will have to be interpreted in light of our law, our rules, and to the extent relevant the Constitution, and as I think was mentioned by the defense, the commitment of these instruments to the principle that proceedings should be held in public. Is that a correct assumption?
All correct, Your Honor. We're using the practice direction because it is another indication in the statutory scheme of the nature of the protected interest that we are identifying under Rule 80. It was decided that at the KSC, at the level of filing practice, that it is best not to identify people from the SPO by their names. And that principle is the same principle that we are applying here. So we are seeing it in other parts of the statutory scheme, but the trial panel is, we would never say that the trial panel is bound by the practice direction. That's not our submission.
Thank you for this clarification. And briefly with the defense, maybe starting with Mr. Cadman, if Mr. Rees doesn't mind, but you've made a submission in your written submission, and again today, about what you claim is potentially the prejudice that would result from the protective measures being granted. What I want to know is really specifically what you say would the prejudice consist of, because as you properly conceded, and so did Mr. Rees, the names of the individuals, their statements, the 9 of them, are available to you. So could you assist the panel in telling us what exactly you would not be able to do, or do it in a manner that you consider prejudicial to you in relation to these 2 witnesses that would be affected should the measures be granted?
Your Honour, I think what we've set out and what we've already said is effectively 2 parts of the argument. One is that proceedings in principle should be in public, and we've made that point very clear. The other point that we've made is it is not merely knowing the identity, counsel knowing the identity of a witness. There are certain aspects of all aspects of that witness's identity being subject to cross-examination. We have to be able to put questions to that witness based on who they are and what their function is. Now,
well, may I stop you there, Mr. Cadman, that you would be able to do that to the extent it doesn't reveal their identity. I mean, this is the measures, as I understand them, sought by the prosecution would not deprive you of this possibility. Quite the contrary. I mean, are you suggesting that the specific identity of 1 or 2 of these persons is at stake in your prospective cross-examination, or are you saying something else?
well, Your Honour, these are the only 2 witnesses that have been called by the prosecution. There are no other witnesses that we are going to have the opportunity to cross-examine. The prosecution is not calling any of the witnesses that at least one of their witness subject to protective measures is alleged to have contact with. There are, of course, matters, and perhaps the court should view this in the context of this case as a whole. And we have set out a number of restrictions that have been placed on the defence, but the only 2 witnesses that have been called by the prosecution are 2 of their own witnesses, which, yes, we know their identity. But you are depriving the defendants from the right to confrontation. You are depriving the public from the public nature of these proceedings. In terms of whether there are specific limitations on what we can cross-examine those witnesses on, not knowing their identity, I'm not in a position to set out at this stage whether there are specific limitations by not knowing or not having that person's identity known. But it is quite clear that the evidence that they're putting forward, the way in which their evidence is going to be assessed by virtue of who they are and what evidence they are presenting. It is very difficult for us at this stage to be able to foresee every single circumstance in which we are going to be prevented from cross-examining them on. The point of the matter must be more a question of whether there is a necessity and whether the Specialist Prosecutor's Office has established that necessity for withholding certain aspects of their identity.
And maybe a follow-up, and it's going to be the last to this line of questions, but assuming that there might arise circumstances in which you are indeed minded to ask a question of either of these witnesses that could reveal their identity, should, of course, the measures be granted, wouldn't the solution be for you to ask for a closed session in which this can be done, and put aside the general issue of the publicity of the proceedings? I'm asking specifically about what prejudice this would cause, if any, to your client. If you are, as could in theory occur, in need of asking a question that could have the effect of revealing the identity of either of these witnesses, wouldn't the solution be to ask the Chamber to go into closed session for the purpose of these questions?
Your Honour, yes, and that is, of course, something that the trial panel may have to consider at some stage. What it could mean is that the entirety of that evidence going into closed session, that is a risk that we foresee. Of course, there can be certain aspects of that evidence being in closed session, but our concern is that in order for us to put questions that we need to put to these two witnesses, there is a risk of the entirety of that cross-examination going into closed session.
I'm grateful, Mr. Cadman. Mr. Rees, any submissions?
2 points, if I may. On the specific point that Your Honour was asking Mr. Cadman about, namely the effect on defence, the defence and defence preparation of granting a protective measure so that the witness can only be referred to by pseudonym. It has an effect which goes beyond the process of examination in chief and cross-examination and re-examination. We are, of course, still undergoing investigations. We are continuing to prepare for trial, including continuing to speak to potential defence witnesses. The conduct of SPO officers in this case, as I hope is clear from the detailed defence pretrial brief that has been submitted, is an issue. And the granting of a protective measure to the two officers, one of whom was involved in actually searching the KLAWVA premises in September last year, will hamper our ability to properly investigate this case. It will hamper our ability, for example, to investigate whether there are any specific concerns about the credibility of that witness that might arise from speaking to potential defence witnesses. Because that witness can only be referred to by pseudonym, which will mean nothing to a potential defence witness. So I add that. There is a second point that I wish to raise that arises from the submissions made by Mr. Halling. He referred to a filing in the case of Thatchy and others, which set out, he said, the environment as it exists at the moment in Kosovo in relation to witnesses. If that is relied upon by the SPO in these proceedings, for this application, they should serve it upon Mr. Gucati and Mr. Haradinaj, because I haven't seen that filing. I got no idea what it says. And that approach from the SPO, frankly, is symptomatic, referring to material, relying on material, which has not been disclosed to the parties. Perhaps the SPO can assist whether, in fact, they do rely on that filing, and if so, they can disclose it to us in these proceedings so we can consider it and respond to it.
Thank you, Mr. Rees. Any submissions in response briefly, Mr. Halling? We've all been generous with ourselves with the 5 minutes we inflicted on us. So briefly, please.
Certainly. As to what Mr. Rees just commented upon, the filings relied on are in footnote 4 of our request. They are public. There is no need to serve them. Everything that we are relying upon is in the public filing accessible on the KSU website. And the last thing I was going to mention, just in terms of the scope of what we are requesting, there is no prohibition, if this application is granted, on using the names of our witnesses when strictly necessary in defense investigations. That is not what we are requesting. Nor are we requesting that everything be in private session. Our intention is to have a limited discussion in private session on the identity of the investigator and the other witness at the beginning of their examination, and then to proceed with basically the entire direct without needing to go into private session again. So this is a very discrete thing that is being requested, and we would just ask that it be understood in these terms.
Thank you. Those were my questions. I think Mr. Cadman is on his feet.
Oh, Mr. Cadman, I'm sorry, go ahead.
I'm grateful, Your Honour. Just to comment on the last point that's been made, it certainly was not my understanding that, based on the application the prosecution has made, we would nonetheless be entitled to provide the details of those witnesses to our own defence witnesses. As Mr. Rees has quite rightly said, there are aspects of what we would need to put to these witnesses, and it's more of a question of not what they can say, but what they can't say, that we would need to put to our own defence witnesses. So I would ask the court to take that into account. Surely the fact that they're now saying that we can disclose the identity of those two witnesses subject to protective measures, if granted, to our own defence witnesses for them to comment on it, surely that undermines the whole basis upon which the application is being made. It renders it completely unnecessary.
Thank you, Mr. Cadman. Perhaps I could suggest that you have an inter-party discussion about this. There's nothing stopping you from doing that. It seems there was a misunderstanding about that, so I would suggest you take this opportunity and others to talk to each other. We can move to the next topic, which concerns the SPO's proposed definition of a witness. And Judge Gaynor has indicated a desire to ask some questions on this topic. So, Judge Gaynor, you have the floor.
Thank you very much indeed, Mr. President. Before I move to that topic, I just have one further question for the defence, for the prosecution, in respect of the European Convention of Human Rights. And you said that there are some decisions from the European Court of Human Rights where it has been found that there has been no violation of Article 6 of the Convention, where police officers have not been identified in the course of trial. And do you accept that there's often a distinction at the domestic level between the testimony of police officers who have testified about undercover activities and police officers who testify about non-undercover activities? And if so, do you accept that most of the Strasbourg jurisprudence you referred to relates to undercover police activity?
Yes, Your Honor. We do accept that there's a distinction to this effect. It is going to come up later in this hearing, I'm sure, when we discuss entrapment and other issues. But yes, the European Court of Human Rights case law, just for the benefit of the panel that I was referencing, the case in particular is Lakunin and Meninen versus Finland. And you can see the consideration that was motivating my submission. It's in footnote 15 of our bar table request. And that is not in the other undercover police context, if I recall. So there is a distinction in the ECHR jurisprudence, and we are on the non-undercover side of that distinction.
Very well. We'll now move to the definition of witness, and as directed by the panel's 21st of July order, the SPO filed on the 23rd of August submissions in relation to the definition of witness, and the SPO set out 5 categories of individuals who fall under the definition of witness. I have one question which concerns the status element as it's been referred to. Now, in paragraph 4 of the SPO submissions, the SPO states that none of the 6 crimes charged in this indictment, in this case, has a status element that the conduct of the accused must relate to someone who is a witness. However, retaliation, which is count 4 of the indictment, under Article 388, subsection 1 of the Kosovo Criminal Code, may only be committed against a person with the intent to retaliate for providing truthful information relating to commission or possible commission of any criminal offence to police, an authorized investigator, a prosecutor, or a judge. Now, the SPO notes in its submissions that in his confirmation decision, the pretrial judge in this case, at paragraph 54, made it clear that retaliation under Article 388 of the Criminal Code relates only to a person providing information to the Special Investigative Task Force and or the SPO about any crimes or offences falling under SC jurisdiction. Now, similarly, intimidation under Article 387 of the Criminal Code relates not to any person, as the SPO appears to suggest at paragraph 5 of its submissions, but to, as the pretrial judge said at paragraph 58 of his confirmation decision, to any person making or likely to make a statement or provide information to the police, a prosecutor, or a judge. Now, these persons appear to fall squarely within the definition of witness set out by the SPO at paragraph 3 of its 23rd of August submission. So my question is to the SPO, and of course the defence will have an opportunity to respond, do you maintain your position that counts 3 and 4 of the indictment in this case do not have a status element, that the conduct of the accused must relate to someone who is a witness? Mr. Howling.
Yes, Your Honor, we do. And the point that I wanted to focus the trial panel's attention on is actually footnote 8 in that submission on a witness. The Kosovo Criminal Code is making a distinction as it goes through these kinds of offenses against the administration of justice crimes. And they are using the term witness in some of these crimes and not in others. In intimidation and retaliation, Your Honor cited to the code provisions, it talks about persons doing particular things or being intimidated or retaliated against for doing those things. But it doesn't use the word witness. And because witness is used in other crimes around the same point in the code, we are ascribing meaning to that. So all that is required is that someone is a person. And truth be told, someone might, under any definition of a witness, could still be providing information to prosecution authorities. Think of an anonymous informant, for instance, without actually qualifying as a witness or being questioned as a witness. This isn't part of the legal elements of the crime. We acknowledge that witnesses are a common fact pattern, that the kind of people that would be intimidated and retaliated against falling under the code would often be witnesses, as classically understood. But it's not an element of the offenses. And that was the point that we were stressing in our submission, and you can see that most clearly from other code provisions which we're not charging.
Okay, thank you, Mr. Halling. The defence will have an opportunity to respond, but this might be an appropriate moment to take a break. I'll leave it to the presiding judge.
Second, I'm sorry. Go ahead if it's short, and you can turn your microphone on. I didn't turn mine on either.
I apologise. No, I'll be very brief. I simply acknowledge the clarification that's been provided by the SPO as to their interpretation, their approach to the word witness and also potential witness. It will assist us in the preparation of the case to understand how the SPO have approached those terms. But I don't have any further submissions to make at this stage. Obviously, in due course, we will be looking at greater detail as to the elements of each offence. But I don't specifically respond to the SPO's submission. It's simply there to give us some assistance as to their thinking and their approach.
Mr. Cadman, anything?
Conscious that the interpreters will need a break, I will also defer to when we deal with the elements.
Thank you very much. Anything else, Madam Judge?
No, thank you very much.
All right, we will take a 30-minute break. We will be back here at 11:35.
All rise. rise.
I realize this is the first day and you don't know what to expect from us, but we do like to start on time, so please do your best to be in the courtroom at the time we designate. We can now move to the next topic, which is bar table motions. In relation to this topic, I'm going to give the floor to Judge Mitro, who has expressed an interest in asking some questions. Judge Mitro.
Thank you, Judge Smith. In order of the 21st of July of this year, we invited the SPO to consider the possibility of filing a bar table motion before the 8th of September and pointed in particular to three categories of proposed exhibits that are on their annexes. That's SPO so-called official notes, newspaper articles in respect of which the author will not be called, and Facebook postings attributed to the accused. Maybe as a matter of clarification that might assist the parties in answering our question, this step was taken with a view to ensure that both parties, the prosecution and the defense, had clear and timely notice of what evidence the panel will admit or will not admit on the record of these proceedings, so as to avoid any prejudice to either or both party that could result from a decision taken at a later stage in these proceedings. So I hope it clarifies things. Now, yesterday we were in receipt of an application from the bar table, as the expression goes, from the prosecution in relation to a proposed 4 or so 100 exhibits. And I will start with a number of follow-up questions for the SPO, and I will turn in a second to the defense. So, Mr. Harling, if it's you again, the first one has to do with protective measures. We want you to clarify whether there is any intention on your part to seek the admission of any of these proposed exhibits other than as public exhibits.
Yes, Your Honor, we do. So most of the exhibits, their classification can be kind of derived from the way in which the exhibit is presented. A media article or a video taken from open source is not going to have a confidential classification. Official notes documenting SPO investigative activities are understood to have, at least as a starting classification, confidential. So we haven't described it as a protective measure as such, because this is just the initial classification that we have issued, but we are obviously aware that the trial panel has the authority to reclassify anything in the record that they see appropriate, including exhibits.
Well, thank you. I think I can safely say that you should prepare yourself for making these submissions in writing, of course, not at this point, so that we are in a position to make the determination of substance in relation to admissibility, and if necessary, to grant or not to grant measures that you would seek in relation to individual proposed exhibits. That's the first question. The second has to do with something you say in your filing, if you want to turn to it. That's the bar table motion. At paragraph 26, you make the submission that in relation to what the defense says is the non-exclusive use of their Facebook account, and your submission is that this claim or the argument that the defense is putting forward is, for the purpose of the bar table motion, an issue of weight rather than admissibility. Do we understand these submissions correctly?
You do, Your Honor. Our submission is that the differential standards of proof come into play here. As to admissibility, we have established prima facie, relevant, probative, that these Facebook posts were made by the accused, or at least someone on their authorization, that they are their statements. At the end of trial, there might be a reasonable doubt, there might be something as regards to the weight of the evidence that it might be considered differently. But at the question of admissibility, the possibility that someone else could have accessed the post in our submission shouldn't be considered. It's prima facie admissible, it should be admitted in the record, and the judges can decide at the end of the trial whether we discharge our burden of proof in being able to fully rely on those statements.
Well, let me test that assertion with you a little bit more, but let's assume we were to accept the position of the defense that the Facebook accounts were not under the exclusive use or without the knowledge, let's assume, of either or both of the defendants. In other words, that you have failed to establish that this is either their account or that they were aware of what activity was going on their Facebook account. What would you say then is the relevance of that material? Because, as you say, of course, the criteria for admissibility are not exactly identical as those that will be required of us to assess at the time of writing the judgment. However, relevance is also something that goes to the admission and not just to the evaluation of weight. So assume for the sake of argument that we were to accept the defense submission on that point. What would you say then is the relevance of that material to your case?
The way I understand Your Honor's question is that if the defense's fact is accepted, that they did not have exclusive access to the Facebook account, what relevance can be drawn from the posts? And to that we would say quite a bit. There are indicators from the way in which these posts are written that they are written by the accused or someone on their behalf. There is no evidence in the record, in contrast, that they have disavowed any of these posts or deleted them or that they have done anything to prevent them being associated with these words. And there is
maybe
yes.
I'll stop you, Mr. Halling. Maybe I wasn't clear enough. Let's assume, for the sake of argument, that they are right, the defense, that is. So let's assume you are not in a position to establish the facts that you have just outlined. Let's assume you are not in a position to establish that they were aware or that they are responsible for this activity on their account. What would be then the relevance of that material to your case if you fail at that point?
If it is determined that there is a reasonable doubt that these Facebook posts can be attributed to the accused, then I would guess that the judge's reliance on them would be quite limited. But that involves accepting a second inference presented by the defense, which is not established by the evidence. This is a circumstantial evidence problem. There is a Facebook post. Who does it belong to? Who is responsible for it? And there is abundant evidence supporting the inference that it was written by Gucati&Haradinaj or on their authorization. There is no evidence to the contrary. And so, I guess our submission would be that they would need to present something to justify there being a reasonable second explanation as to what happened here, because all of the evidence is pointing to the fact that these are their posts.
Thank you, Mr. Halling. I won't belabor, but I do suspect that the answer from the defense will be we don't have to put anything forward. It's for you to exclude that possibility. But I'll come to the defense in a second, and if you do not mind, I will go on with a few more questions for the prosecution and then turn to you. The second question that I have in relation to this motion has to do with what you have renamed so-called contact notes. Do note that they used to be called SPO official notes, and that's the name that's given to them on the physical pieces of paper that we were given. So I note this change of terminology, but I'm more interested in the substance of these documents. You make the submission, and we accept that submission at paragraph 27 of your bar table motion, that these document pertain to witnesses. That's what you say at paragraph 27. And then you acknowledge that these notes contain the records of what these witnesses have said to either investigators of your office or in some cases prosecutors or prosecutors and investigator. And then there is an assertion on your part to the effect that these notes, official notes, were not taken for the purpose of legal proceedings. And I want to test that claim with you. At paragraph 27 of your motion, you say that these notes resulted from effectively an initiative intended to check on the well-being and security of these individuals. Now, assuming that one of these persons would express a security concern or a safety concern to you, one, I would think, of the steps that could be taken by your office would be to seek protective measures, I assume, in relation to one or several of these individuals with a view to deal with the risk that is resulting from the situation. Would that be a correct assumption? That's one of the steps that could be taken by your office.
That's correct, Your Honor. For the cases that these people apply to, it would be a Rule 80 application in that case. As we explain in our motion, these are not witnesses in the Gucati&Haradinaj case, and as a result, it's our submission that we don't have to affirmatively justify the protective measures. I take Your Honor's note that you would like a submission from the SPO as to why certain materials in the submitted evidence are classified as confidential. And we can make a submission to that effect. But even then, we wouldn't be asking for protective measures. We would be justifying our initial classification of the evidence no differently than if we'd made a confidential filing and then we're asked to justify its status.
My point was slightly different. My point is this. If one of your investigators or prosecutors calls an individual who informs you that he or she feels threatened or has concrete evidence to that effect, one of the steps that you may take is to seek protective measures from the court to deal with this matter, either as a general precaution or in relation to the case in which he or she would be testifying. And my question is, that is legal proceedings, correct?
The statement of the witness was not taken in the context of legal proceedings. If that definition that was suggested in the question were the definition of legal proceedings, then it would not be possible to check in on the well-being or the security of a witness without taking a statement. And not only would this impact protective measures, but it would also impact disclosure. We have an obligation to disclose all the statements of our witnesses. People that have security concerns raised, our understanding is that's not, strictly speaking, part of the legal proceedings. It could then become part, but for the definition of Rules 153 to 155, and you can see the cases that we cite distinguishing these kinds of considerations from more classical statements, that is the limitation that these rules are putting on what falls within their scope.
I think the sensitive aspect of your submission is stricto sensu. If the purpose is to make a risk assessment, of course, one of the possible, if not likely, consequence of that exercise is potentially legal proceedings. Now, I will leave it to you to consider further. I'll ask you for a similar question, or at least going to the same direction. It's a submission you make at paragraph 32 of your motion. It says this, I'll read it for you. Talking about these notes, you say, these materials are also evidentiary indicators that the conduct of the accused was intimidating and or retaliatory within the meaning of those crimes being the crimes with which you charge both defendants. Now, as I understand those submissions in your own words and submissions, as you are collecting information from these individuals, you are becoming aware of the potential commission of what you say are crimes within this jurisdiction. Is that assumption correct?
Whatever information we acquired was incidental to the purpose of the statement. We were not, these contact notes were not created. By the way, they were called contact notes just because there are official notes in other categories. We weren't trying to change the meaning of the definition. We were trying to be precise as to what kinds of official notes are at issue. But they were not taken for use as evidence in the proceedings. If you look at the pretrial judge's decision, which granted non-disclosure of these materials, the counterbalancing measure that was ordered was that we provide these official notes to the defense. So there was not we were not planning on using these in the proceedings all along. Many of them were disclosed as a result of this decision, and once they were disclosed, it was then decided to use them as evidence. But the character of the contact note wasn't for purposes of legal proceedings. It was for the purposes that are identified in the request.
So let me push it one step further. Let's assume you are doing something for one purpose. As you are collecting this information, you, in your own submissions, are becoming aware of the potential commission of a crime that comes within your competence and the jurisdiction of this court. Those are, in effect, your submissions. Now, at that stage, are we looking at something that could qualify as legal proceedings, or are you still asserting that we have to look backwards at what was your initial purpose for getting in contact with these witnesses in the first place?
Our submission is that it would be a holistic assessment in order to make this determination. What are legal proceedings is a term of art in this context. Rules 153 to 155 are based on rules in international tribunals. Rule 68 of the ICC rules, Rule 92 bis, 92 ter, 92 cotter, and 92 quinques of the ICTY rules. Because of the similarity in the provisions, it's in our submission that the jurisprudence from these tribunals on the meaning of the provisions is relevant here. And they are describing legal proceedings as being a limit as what falls within the scope of the rule. And the kind of latent appearance of relevance to the legal proceedings, the kinds of information that you're describing in your question, you can look at the Ongwen citation, you can look at the Lubanga citation that we have where security notes of contacts were admitted through the bar table. It's not being understood in the way that is addressed in the question. It's being understood in a more discrete sense, and we are arguing that that more discrete sense is the proper ambit of Rules 153 to 155.
I'm grateful, Mr. Hadding, for those submissions. I have questions for the defense as well. If you don't mind, I'll ask those questions, and of course feel completely free to respond to the submissions of the prosecution on any of my questions, either as part of your responses or as at a later stage. But one clarification that I want to look from you, Mr. Cadman, is in relation to something that is not entirely clear, at least in my mind, from your submissions. And the question is this. You address in your submission what was then a prospective bar table application by the prosecution that has now come an actual application to that effect, and you seem to take quite a principled objection to the issue, and of course that's absolutely your right and entitlement. But what I want to understand from you is whether your position on the law is that this panel is not permitted to issue a decision from the bar table, which, using a non-technical term, is an application by motion, Or are you saying something slightly different, which is that in the exercise of our discretion, we should not be admitting the evidence in this matter? So could you please clarify this for me?
Thank you, Your Honour. It's certainly the second position that you put forward. We are not saying that the trial panel is precluded, but obviously there has to be some exercise of discretion as to what is included. What we have set out, and bearing in mind we only received the motion yesterday, and we will be exercising our right to respond within 10 days in written submissions to that. What we have stated is that the use of bar table should not be used as a way to circumvent the usual procedures under proper disclosure.
Thank you, Mr. Cadman. Stay on your feet if you may. I have a couple more questions for you, but of course you will be entitled to respond in writing to the substance of the application, and I'm not trying to put you on the spot in relation to any of these issues. So if you feel that you would prefer to reserve your position for your written submission, feel free to make that clear to us. But there's one issue that I would like to address with you. It's again the claim that you made at the time, and I understand you might be taking a different position now that you have the prosecution submissions in front of you, but there was a suggestion that entertaining such an application would necessarily and unavoidably cause you prejudice. And again, my question is whether this should be qualified in the sense that it was the reflection of a concern that you had shadow boxing effectively against what might come your way. Is it still a concern that you have today? And if that's the case, could you specify what prejudice in particular you are concerned about, and as specific as you can be, of course, without disclosing anything that is confidential?
Certainly, Your Honour. And to adopt Your Honour's term of shadow boxing, which was exactly the position we were put in, not knowing precisely what were going to be the parameters of the application, which we now have. All I can say at this stage, and we will reserve our position for it to be in written submissions, as obviously preparing for today's hearing. We only received the application yesterday, and I wouldn't want to put forward something that changes as a result of later having considered the full application. What the position that we put in terms of anticipating what was going to be the application was that there are very real concerns as to the amount of material that would be included, that we would not have an effective opportunity to challenge the authenticity, the absence of chain of custody of certain material. So there are concerns that without having the authenticator of that material that we would be able to cross-examine, then that would put us at a significant disadvantage. But of course, I would much prefer to be able to put that more eloquently within the 10 days afforded to the defence.
So we'll expect eloquence from you, Mr. Cadman, but simply also before you sit down, maybe to put your mind at rest about something else you said at the time when maybe concern was greater than it needed to be. But it's the fact that, of course, if we were to entertain the prosecution's application in its entirety or in relation to at least some of the material that they are proposing to tender in that way, we would be, as is the practice, deal with each item of evidence that is being put forward. So if there are those concerns that you have voiced, which are legitimate, in relation to any particular items of evidence that's being proposed, we would hope that as part of your eloquent written submissions would have indications of those specific exhibits that give you those concerns. And as I promised Mr. Rees to give him a chance to be heard, that's now your chance, Mr. Rees.
Not guarantee eloquence, but I will do my best, having reserved our position to consider the very full and lengthy application with its annexes. With due consideration, we will respond at that stage. I do add this. we support the rendering of a decision in respect of admissibility of this substantial application prior to the prosecution opening. That will be our position. To the extent we also support oral argument being heard on this matter, but once we've had time to properly reflect upon the detail of the application and respond in writing first to give the trial panel the assistance of our submissions in writing before we expand upon them orally.
Thank you. Those were my questions. Concise is almost as important as Mr. Cadman's commitment to his own submission. So thank you, Mr. Rees.
Sorry. So we move on to the written submissions requested from the defense, and the first issue to address relates to the defense submissions on entrapment or incitement. And before we go into the details, I have an oral order to make. The panel has taken notice of the decision of the Court of Appeals panel issued on 29 July 2021, in which it found that the defense was deprived of the first step of Rule 102 sub 3, namely the opportunity to be informed of the materials in the possession of the SPO relating to the process through which alleged confidential material arrived at the premises of the KLA War Veterans Association. That the pretrial judge erred in finding that this issue was not relevant to the case, and crucially, that the SPO should have included material in its possession falling under the so-called Gucati requests B.C. in its Rule 102.3 notice. In light of this decision, the panel orders the SPO to submit an updated Rule 102 sub 3 list by 6 September 2021, orders the defense to indicate to the SPO by 9 September 2021, or at any time earlier, which items among those listed in the updated detailed notice they seek to have access to by way of disclosure or inspection, orders the SPO to seize the panel by 15 December 2021 with any grounds disputing the materiality of evidence or requests for protective measures or non-disclosure, orders the defense to respond, if they so wish, by 20 September to the aforementioned SPO requests, and orders the SPO to disclose to the defense the sought material that is not subject to the aforementioned requests by 17 September 2021. Did I say something other than 15? Was it December? Oh, 15 September is the date for the order, the SPO to seize the panel. This concludes the oral order. And now I give the floor to my colleague, Judge Gaynor, who has some questions on the topic of entrapment and incitement.
Apologies, Your Honor. Is it possible to take the floor briefly before those questions?
Yes.
It's okay, yes.
Just for a moment in relation to the oral order just given. If it's the SPO's position that updating the Rule 102.3 notice in the manner Your Honors just described would involve revealing information that would be subject to protective measures, even just on the list, is it within the scope of your Chamber's briefing schedule to file a request to the Chamber, confidential ex parte, to that effect, with sufficient time to rule on it by the 6th, so that we could at least be heard on this point before having to update the Rule 102.3 notice?
We'll amend our oral order later on, either today or tomorrow, to include a response to your request.
Thank you, Your Honors.
All right, Judge Gaynor.
Thank you, Mr. President. Now, on the 21st of July order, the trial panel instructed the defence to file additional submissions on entrapment. and the SPO was ordered to provide its response orally during today's hearing. Therefore, I'd like to invite the prosecution to address the panel on this issue.
Thank you, Your Honors. The SPO's position is that there is no legal or factual basis for a defense of entrapment or incitement, and the defense fails to make out a prima facie case. The cases relied upon by the defense require two elements to establish entrapment. There must be one, an official person taking action, and two, this action must exert such pressure upon the actor such as to incite them to commit an offense that would not otherwise have been committed. And this is from Ramanauskas, the case from the Grand Chamber of the European Court of Human Rights, relied upon by both defense teams. The defense presents no evidence to establish either element. What is alleged is indeed wholly improbable within the meaning of the European Court of Human Rights case cited at paragraph 17 of the Gucati submissions. There was no undercover operation here, no official person acting on the accused, and therefore the defense of entrapment does not apply. Cases like Ramanauskas involve the conduct of police in undercover operations. There is no evidence of such official action here, and the cases relied upon by the defense are thus misguided. There's no evidence that an SPO official was involved with the deliveries of any of these batches. The accused have admitted that their encounters with those delivering the batches were extremely brief and that they do not know who delivered them. There was no opportunity for an official person to even interact with the accused, let alone incite or cause them to commit crimes. In fact, all of the evidence is contrary to the claims of the accused. The SPO reacted with all possible speed following the 3 disclosures. The SPO secured a judicial order following the 7 September 2020 disclosure and seized the materials on 8 September. The second disclosure was also seized the next day. The third disclosure was seized on the same day. This is what the evidence shows. The accused have never themselves said they were incited or entrapped at any point. Instead, they rely solely on allegations about the SPO's investigation and conjure fanciful and false theories about the SPO manufacturing the crimes against the accused. But the evidence, to the contrary, shows that the accused committed the crimes repeatedly and enthusiastically. They had the option to return the materials to the SPO instead of releasing them to the press. They were informed by judicial orders that they were engaging in wrongdoing. They continued to engage in the conduct. They released them to the press on every occasion. They welcomed the delivery of the batches. They promised to publish more as more was received. They wanted to destabilize the KSC and took every available opportunity to do so. They were not influenced, much less overborne by anybody. The defense cannot establish the prima facie threshold to even justify disclosure on these matters, as held by the pretrial judge and confirmed by the Court of Appeal. The defense cannot change the scope of the trial on the merits to present such arguments. And just to finish, Your Honors, the SPO announces that it intends to file a motion to strike defense witnesses and parts of testimony of defense witnesses that are irrelevant to the trial and only go to collateral matters. This includes testimony going to alleged deficiencies in the SPO's investigation and alleged political pressure applied against ULEX or the KSC. Thank you, Your Honors.
Thank you very much, Mr. Halling. I now have a couple of questions for the defence. Now, the defence have outlined in their pre-trial briefs various factors in support of the argument that it would be reasonable for the panel to infer the existence of a plan, a deliberate effort to entrap the accused. We would like to inquire further into your arguments in this respect. First of all, Mr. Rees, do you accept that the defence bears the onus of establishing a prima facie case of entrapment or incitement?
No, I don't accept that.
Mr. Cadman?
It's a position that's been put forward jointly by the defence. No, we do not accept that.
Now, Mr. Rees, in your 27th of August submissions, you've set out jurisprudence of the European Court of Human Rights relating to entrapment.
Yes.
And this suggests that incitement may be by a state agent or a private party acting under the instructions or control of the state agent.
Absolutely.
And my questions to you, first of all, do you consider that incitement by a person not acting under the instructions or control of a state agent constitutes entrapment?
We have set out that we accept that an essential part of a plea of police incitement, as it were, is to establish the involvement of the investigating agency, whether direct or indirect. Does not have to be through an individual officer, does not have to be with the approval of senior members of that investigating agency, but there has to be some involvement with the prosecutorial agency.
Thank you. And analogously, do you consider that incitement or entrapment by a person not acting under the instructions or control of the SPO constitutes entrapment or incitement?
I would qualify that by making the point again that it does not seem to us any part of the case law of the European Court of Human Rights that, for example, the authority of the organisation as a whole, represented either by a senior member of the organisation, needs to be proved or needs to play a part in the incitement. It would be enough if, for example, an agent of the SPO went rogue and acted without the knowledge of any other person within the SPO.
And can I ask you, do you have any jurisprudence, in particular of the European Court of Human Rights, but of any domestic authority or any international court to support that specific submission?
Yes, is the answer. And it is I have referred to Ramanauskas. I can assist further by identifying the specific authority for that proposition. But we say it is firmly made out in the case law of the European Court.
That a rogue
That an agent going rogue is sufficient.
I think the panel would appreciate your identification of the specific jurisprudence.
And I will assist the court with that.
Now, I would like to ask both defence teams, does either defence team currently have any evidence, I mean evidence, not a matter of inference, but evidence that suggests that any current or former member of the SPO or any private party acting under the instructions or control of the SPO delivered or provided the material in question to the Veterans Association? As you're on your feet, we'll start with you, Mr. Rees.
Yes, we say there is evidence. The evidence is set out in a summary form in our paragraph 20C of our submissions, the 27th of August 2021. Circumstantial evidence is evidence. There is no distinction to be drawn between direct evidence and circumstantial evidence. It is evidence. And we intend to call the evidence that we set out there in paragraph 20C onwards to we say the effect that the inference can be drawn without anything further that there must have been involvement from an SPO officer in the process by which the batches came to be delivered to the KLA WVA.
Thank you. Mr. Cadman, would you like to say anything?
Your Honour, just to endorse the position that has been set out by Mr. Rees, and obviously not wishing to present our entire case at this stage, there is, of course, evidence that will be called, as Mr. Rees has set out, both in terms of circumstantial evidence and inferences that can be drawn as a result of the failures of the Special Prosecutor's Office that can lead to only one conclusion, that there had to have been involvement from the Special Prosecutor's Office, either acting directly or indirectly, and evidence will be called to that effect.
Thank you, Mr. Cadman. Now I have two questions for the Prosecutor's Office. Is it the SPO's position, because we've read your assertions in this regard very carefully, is it the SPO's position that there is no information in its possession which could be material to the argument that any current or former member of the SPO or any private party acting under the instructions or control of the SPO delivered the material in question to the Veterans Association?
Your Honor, that is correct. And we've made this submission before. If there was any evidence to that effect, it would not need to be noticed and selected by the defense pursuant to Rule 1023. That would fall under Rule 103. In our opinion, it would be potentially exculpatory. We would disclose it directly, and the Court of Appeals made the same finding. So not only is there no evidence, but this is the reason why no evidence has been disclosed.
Thank you. Those were my questions on this matter. Thank you, Judge. I'll pass to the presiding judge.
Judge Mitro has some questions.
Thank you, Mr. President. Mr. Rees, I will call upon you again on this issue. I think you have answered it, but I will ask you nevertheless. But you accept, like the Haradinaj defense, that the identity of the official from SITF or SPO who, according to both defense teams, partook in the claimed entrapment or an incitement is unknown. Is that correct? You are not suggesting that that person is known by anyone in this court. Is that a correct understanding?
On the information that we presently have, I note, and I'm grateful for the trial panel's oral order earlier on because it saved me from making specific submissions on it, that the SPO has not complied with its disclosure obligations. Stage 1 of the three-stage process, to be applied under Rule 1023, has not been complied with yet.
Mr. Rees, put the disclosure issues aside for a second. Back to my question, and I'll ask you maybe two questions that you can tackle at once. You are not proposing to identify any given individual as part of your case. Your case, as I understand it, and as the panel understand it, is you will seek an inference from the panel that a number of indications, 13 of them in the paragraph 20C that you have identified a moment ago, would allow for the inference that entrapment occurred, or at the very least that the prosecution has failed to demonstrate it to be unreasonable at that conclusion. Is that right? You are not going any further than that, evidently. You're not proposing...
No, as we've said in our defence pre-trial brief, the identity of the person who made the delivery, the identity of the persons who made the deliveries, is unknown.
And so is the person in the scenario that you gave to my colleague, Judge Gaynor. So is, if your case were to be an indirect so-called entrapment, the official that would have been otherwise involved in the matter. You are not proposing to identify this person, correct?
Not proposing to. We can't. We don't know. That's why we've sought disclosure of material that was relevant and should have been listed on a Rule 1023 notice. Once we receive that Rule 1023 notice as amended, we will make such disclosure applications from that list as are appropriate in accordance with the oral order, and we will see where that then takes us, as it were.
Thank you.
But again, I don't think it's any part of the case law of the European Court that requires the identification of a particular officer involved.
That was not the suggestion either.
No.
It was an inquiry about the nature of the case that you proposed to put
Absolutely.
forward. Thank you. Mr. Cadman, that would be your turn. I have a number of clarifications that I would seek from you. I've read, of course, your submissions on that issue, and so you can you do not feel that you have to repeat anything that's in it. But there's a number of issues that arise from it, and maybe our question was not sufficiently clear to you. But at paragraph 30 of your submissions, you suggest that the panel is asking you to justify your claim of entrapment. That was not the intention, and that certainly isn't what we were asking you. What I was asking you, what I want to ask you now is something slightly different. It's about the legal basis that you are relying upon to advance this claim of entrapment. And I will spend a few seconds, perhaps, that will make it clear to you what assistance I'm seeking here. Our understanding is that in some jurisdictions, the notion of a defense of entrapment does not exist. In some other jurisdiction, it does exist. And then you have other jurisdiction, national jurisdiction, where it could be, for instance, grounds for exclusion of evidence, France, for instance, or it could be a mitigating factor, as is the case in Switzerland, if it were to be established that entrapment has indeed occurred. Now, what I want to know from you is very specifically, what is the legal basis? Where does this panel have to turn to find the legal basis on which you ask us to rely to allow what you say is a defense of entrapment? And before you answer that question, may I direct you specifically to Article 12 of our law, which sets out the applicable law, which in summary fashion says that the law that we apply to these proceedings is substantive law, that is effectively either Kosovo domestic criminal law to the extent it's been acknowledged as applicable in this jurisdiction, and or customary international law. So my question to you is a specifically legal one, legal basis, is where is the panel to go to find that this notion of a defense of entrapment is made to be relevant and applicable to these proceedings?
Thank you, Your Honour. Clearly, I did misunderstand the question that was being asked initially, as is clear from the answer in paragraph 30. That was certainly our reading of the order. As Your Honour has indicated, there are a number of different jurisdictions where the defence is looked upon in a very different way. It may constitute an abusive process and a bar to proceedings. As you've already stated, it may also be considered as mitigation or exclusion of evidence. The difficulty we have is that it is not clearly set out in the legal framework of this institution. And to my mind, is not clearly set out in the criminal procedure laws of the Republic of Kosovo either. What we have set out is that it is a defence that can be raised and should be raised in the specific circumstances of this case. And it is, of course, a matter for the court to determine to what extent that defence can be applied and what is the remedy. We haven't set out at this stage what that remedy is. What we have stated that it is a defence. It is certainly recognised under the European Convention on Human Rights, as we've already heard from Mr. Rees on the jurisprudence of the European Court. But of course, we have not set out at this stage, and of course it is a matter to be raised at trial as to whether we can satisfy our burden and whether the prosecution in response can satisfy their burden, and then the result of what that defence actually is. We have not set out at this stage what the remedy is.
Mr. Cadman, I don't want to put you on the spot. I don't think you've pointed to any legal basis, and I won't ask the question again, but I would do suggest that you give consideration to that matter, because of course there has to be a legal basis somewhere, and maybe you can consider perhaps the arguments of your colleague, Mr. Rees, on that point, and see whether they are consistent with yours, because as we understand the position so far, they are slightly different. But as I said, I won't belabor the issue at this stage. But there's something also that I will put for your consideration, either today or at the time that you will choose for your submissions on that point. But we asked you also what the elements of that purported defense of entrapment were, and that was with a view to ensure that this panel, if it was to entertain such an argument, would have a legal basis on which to rely, and then know what the elements of that defense are. And again, as you would probably be aware, the elements of such a defense may be vastly different from one jurisdiction to the other. And your response to that inquiry at paragraph 44 of your submissions was to the effect that the conditions and requirements applicable to such a defense in the special court's legal framework are those that would be ordinarily applicable in a domestic context, the defense of entrapment being recognized as a legitimate defense domestically, and therefore the same must hold true for the purpose of the specialist chambers. Now, with respect, Mr. Cadman, I still am somewhat confused because of the fact that you haven't pointed to a legal basis that would allow us to identify those elements which you say are regulating the law of entrapment that you are putting forward for our consideration. And I don't mean to put you on the spot, Mr. Cadman, on that, but if you wish to address the matter now, please do so. If you prefer to keep this matter for your further consideration and make those submissions later, we'd understand that.
Certainly, Your Honour, as you've graciously given me time to respond to that in full, I will take that time and respond at a later time. If Your Honour would like me to deal with that later today or tomorrow morning, I'm more than happy to deal with it at that stage.
Well, we'll leave that time to you, Mr. Cadman. Of course, it can be done at a later stage, and it's not for us to decide your strategic position. It is simply that it would assist the panel to understand what the legal framework around your argument is said to be by you, so that we can give consideration to that part of your case. Mr. Rees, I will now offer you a chance to comment on anything that's been said, and at the same time, there's a question in my mind that I want to direct to both defense teams, and that is the suggestion, as I understand it at least, is the fact that a so-called defense of entrapment or incitement, depending what term is used, would only ever become relevant to this panel, at least, if and where we were satisfied that one or more of the crimes that are charged against your and Mr. Cadman's client have been established. Is that legal assumption a correct one in your view?
Yes, that's how we've approached it in the defence pre-trial brief. Mr. Gucati raises substantive defences in relation to each of the charges. He does rely on the plea of incitement if the trial panel is against him on any of those charges. If it assists, our submission is that the plea of incitement is a matter that should be tried during the course of the trial. The evidence is effectively one and the same with the matters that the prosecution bring in by way of charge. So, for example, does not seem to us to be a useful process to, for example, hold something like a trial before the trial on the issue of incitement. We would submit that it's a matter that can be dealt with properly during the course of the trial and dealt with at the conclusion of it, as it were.
Thank you, Mr. Reid. May I take it that the position is shared by Mr. Cadman on behalf of Mr. Haradinaj?
Yes, Your Honor.
I have one last question, and it's for you, Mr. Halling. You've indicated that you were intent on filing a particular application, I think used the expression, to strike or strike out certain proposed witnesses who are, to your understanding, to testify to some of the issues of concern. Do you have an indication to give to us of the timing when you would wish to make such an application? And again, not putting you on the spot. If you need more time to consider the matter, let us know.
Your Honor, envisaging what we intend to file, I think we would be able to file it by mid-September.
Thank you.
Anything else? So moving on. Moving on, we have about 25 minutes. We'll start the next subject. I'm not sure we will finish it in that time period. We'll take a break at 1 o'clock, as I had indicated earlier. The next topic concerns the prospective witnesses of the defense. And I give the floor to my colleague, Judge Gaynor, who has some questions on this topic. Judge Gaynor.
Thank you very much, Mr. President. In the 21st of July order, the panel instructed each defence team to submit by the 27th of August a summary of the facts or circumstances in relation to which each witness would testify, in particular in respect of the issue identified by both defence teams as public interest. The SPO was ordered to provide its response orally, if any, during this hearing. I would now like to invite the SPO to provide its response.
Thank you, Your Honors. As we just mentioned on the previous issue, the defense is seeking to elicit a great deal of evidence concerning matters not relevant to this trial, and that the SPO does indeed intend to file a motion to strike this kind of irrelevant evidence. It connects to the discussion on the previous issue, because a lot of the issues that are manifestly irrelevant seem to be going to this entrapment, incitement issue. The reason why the defense teams are struggling to identify whether or not this is a substantive defense or what the elements are is because it isn't. It is something that would be more akin to a procedural motion on the fairness of the trial, or to have evidence of the SPO to be excluded. It is the difference between whether or not evidence should be elicited during trial on the merits of these questions, or whether it's a collateral issue. And our position is that a lot of these points that are going towards things like incitement or entrapment are not going to the merits of the trial.
Can I interrupt you for a moment? We're dealing with the interest of the issue of public interest. We're now finished with entrapment and incitement. A number of the witnesses which have been listed by each defense team are being called, it appears, in respect of an issue of public interest. Now, do you have any specific response to give right now on that specific point?
On the specific point Your Honor raises, it depends on what the public interest is. Our understanding is that the public interest is going to this same point in trying to expose matters on the political dealings of institutions or whistleblowing that are sort of relevant to the defense they're mentioning, which is why I link the issues. But in short, public interest alone is not a justification for eliciting relevant evidence at trial, and we intend to address this in our filing.
Thank you very much indeed. Now, I'd like to turn to the defence teams. Is it the defence position that acting in pursuit of the public interest, which is referred to in your filings, is a substantive defence to any of the charges in this specific indictment, in this case, taking into account the restrictions on freedom of expression set out in Article 10.2 of the European Convention of Human Rights? And if so, to which specific charges is public interest a defence? I can start with Mr. Cadman.
Put simply, Your Honour, yes, it is. The defence intends to call evidence to demonstrate that, and by virtue of calling witnesses of fact and expert evidence as to the public interest defence on the disclosure.
Thank you, Mr. Rees.
Yes, we agree. Whether it's characterised as a substantive defence. We agree with the position of Mr. Haradinaj. Whether it's characterised as a substantive defence or whether it's characterised as part of the process of analysing whether the prosecution have proved beyond reasonable doubt the elements of each offence, we do say that it's important that the court considers the accused's rights to freedom of expression and the public interest that is inherently protected thereby.
And are you able, Mr. Rees, to assist us with any citations in Kosovo law or to any jurisprudence of the European Court of Human Rights or the ICTY or any relevant court which support the argument that public interest is a valid defence to charges similar to or identical to the indictment in this case?
What I do point to in the defence pre-trial brief at some detail is the accused's rights that are protected under Article 22 of the Constitution of the Republic of Kosovo, Article 19 of the Universal Declaration on Human Rights, Article 19 of the International Covenant on Political and Civil and Political Rights, Article 10 of the European Convention, Article 41 of the Constitution, and Article 42. These offences are specific to the Kosovan Criminal Procedure Code. There is no body of case law that provides any real assistance to the trial panel on the interpretation of them, as is clear from the decision on the confirmation of the indictment from the pre-trial judge, in which he embarked on the interpretation of the offences with very little citation of authority to assist him in doing so. We will invite the trial panel to look in detail in the offences themselves, and the trial panel will have to reach its own interpretation on the scope of these offences, and we will submit as part of that exercise. The trial panel will have to look at the constitutional rights that are guaranteed to Mr. Gucati in relation to freedom of expression.
Thank you very much, Mr. Rees. Mr. Cadman, I'd invite you to identify, if you can, any specific jurisprudence or provisions in domestic law which go to the issue of public interest as a defence to charges, specifically the charges in the indictment here.
Your Honour, as Mr. Rees has already stated, there is no example of any of the international or ad hoc tribunals where this has been argued before. This will, in effect, be the first time that it's been argued in proceedings such as this. There are, of course, examples where a whistleblowing defence, public interest defence, are argued or have been successfully argued in the domestic legal arena. And certainly the purpose of calling the expert from, which we have listed from the Whistleblowing International Network, is to set out the European legal framework, including the EU directive on whistleblowing. And so that is the purpose of why that will be argued at trial.
And in respect of the expert witness that you've just referred to, who I believe appears on both defence witness lists, when do you anticipate that you will be ready to disclose the final report of that expert, including the expert's qualifications, to the SPO in accordance with Rule 149?
If I could just take a moment, Your Honour. We anticipate that we would be in a position to serve that within the next 4 weeks.
Thank you, Mr. Cadman. I now move on to the witnesses that have been listed by both defence teams. These are fact witnesses, as far as the panel understands, who it is said will testify on whether the accused were acting in the public interest / can be classified as whistleblowers. That's a direct quote. Are you able to let the panel know at this stage what are the specific facts that those witnesses can testify about that are specifically relevant to the charges set out in the indictment in this case? Mr. Cadman.
Your Honour, we've set out in our written submissions who the witnesses are that we intend to call at this stage. There may well be applications for further witnesses in due course as defence investigations continue. We've set out the details as we see we are required to disclose at this stage. We do not consider it necessary for the defence to disclose the entirety of its defence case at this time. What we have set out are a number of witnesses of fact and those witnesses who can talk about the public interest in the disclosure matters. They are made up of those that were employed by the War Veterans Association at the time. There are journalists, and there are those that have had experience with the ULEX system that will go to the public interest defence.
Thank you. Mr. Rees, would you like to add anything as to the facts that these witnesses will testify about which are relevant to the charges in this indictment?
We have, of course, submitted a detailed, lengthy pre-trial brief on behalf of Mr. Gucati, which sets out therein the issues of fact that will be relied on in relation to what is being characterised as shorthand as public interest issue. As we have put in the defence pre-trial brief, we have referred to the accused's rights of freedom of expression. We have referred to the Constitution of the Republic of Kosovo as modern, open and liberal. It is a rejection of the secretive, authoritarian, repressive years that Kosovo endured under the communist Yugoslavia and then nationalist Serbia. That under Article 2.3 of the Kosovo Criminal Code, the definition of a criminal offence is to be strictly construed. Interpretation by analogy shall not be permitted. In the case of ambiguity, the definition of a criminal offence shall be interpreted in favour of the person against whom the criminal proceedings are ongoing. Similarly, any limit to the exercise by the accused of his constitutional rights must be strictly construed and applied only where clearly demonstrated to be strictly necessary and in accordance with the law. And Articles 22, 40, 41 and 42 of the Constitution, which confirm the accused right to freedom of expression.
Mr. Rees, if I can just interrupt for a second. We're specifically interested in knowing the facts that these witnesses might be able to testify which can assist this panel taking into account the charges in this particular indictment.
Yes, and I follow the nature of the request, and it is spelled out in the defence pre-trial brief, which is why I was coming on to it. But it is important that the trial panel understands our position, it's been referred to as a defence of public interest. And we raise the public interest because it is an important part of the task of the trial panel. I don't characterise it as a substantive defence, however. It will form part of the considerations of the trial panel when they come to consider the scope of the offences, construing them narrowly. And we're not dealing with offences that have been dealt with in other international criminal courts, because these are offences created by the Kosovan Criminal Code, which is subject to the specific rights protected in the Constitution of Kosovo and the other instruments that are specifically adopted in that Constitution. So the interpretation of those offences can only be done by reference to the other rights that are guaranteed within the Constitution. In relation to the facts, we have referred in the defence pretrial brief to the fact that the content of the press conferences referred to, and the purpose of them was to make public the collaboration between the SPO and the Serbian authorities. That is essentially the matter of public interest, the fact that goes to public interest that we rely upon. And we have made that clear, I hope, in the very detailed and lengthy 107-page defence pretrial brief, responding paragraph by paragraph to the prosecution pretrial brief.
Thank you, Mr. Rees. We'll return to that issue a little later. But for the moment, the issue of the collaboration, as you describe it, between the SPO and the Serbian authorities. So we will have the opportunity to return to that. At this stage, would the SPO like to respond to anything, taking into account what you've already said and your upcoming motion that you've indicated to all that you intend to file?
I think our position on the matter is clear, Your Honour. Unless you have further questions, we have no further submissions.
I have no further questions. Thank you, Judge Smith.
Thank you, Mr. President. So I will briefly summarize what at least is my understanding of the position of the defense as far as the legal basis, again, question is concerned here. Mr. Cadman, you have not pointed to any particular legal basis where the panel would have to look to find what you claim is a substantive defense of entrapment or incitement, while counsel for Mr. Gucati, Mr. Rees, is suggesting a slightly different route through provisions of the Kosovo Constitution, Article 3 and 22, I understand, and a number of provisions from relevant human rights instruments, including Article 6 and 10 of the European Convention of Human Rights. Now, assuming, for the sake of argument, that these provisions that Mr. Rees has put forward as underlying legal basis for the claim or defense of public interest, I would be interested in knowing what you say is the definition of that notion, to the extent that we will have to apply that definition to assessing the evidence that you will seek to offer to the panel to determine whether one fits into the other. And having conducted diligently, I hope, a little research on that point, we could identify one definition of public interest under the applicable Kosovo legal regime. It's at paragraph 4 of Article 200 of the Criminal Code. That refers not to something that is, I should make clear, directly relevant to these proceedings. It's the unauthorized disclosure of confidential information. It is not a provision put forward by the prosecution, but it does helpfully define public interest in those terms, and I would like to read it to you. It says that public interest means the welfare of the general public outweighs the individual interest. The disclosure of confidential information is in the public interest if it involves plans, preparation, or the commission of crimes against the constitutional order or territorial integrity of the Republic of Kosovo, or other criminal offences that will cause great bodily injury or death to another person. And my question to both counsel for the defense and prosecution can of course address the issue as well if they so wish, but is that a definition that you accept to be reflecting your understanding of what public interest stands for the purpose of these proceedings, or are you suggesting that another definition should apply, and if the latter, can you tell us where we should be looking for it? And Mr. Cadman, perhaps, to start with.
Your Honour, that is one of the definitions under Kosovo law where it deals with public interest, and that is one of the definitions that we say the trial panel will have to consider. I do not have a copy of it with me, but I'm sure that we can provide a copy towards the end of the day. That there is also domestic legislation that deals explicitly with the defence of public interest under whistleblower. But I'm more than happy to ensure that that is provided to the trial panel.
We'd be grateful, Mr. Cadman. Mr. Rees?
Well, I'm very grateful for Your Honour's reference.
I think, Mr. Rees, you have a microphone issue.
I'm very grateful for Your Honour's reference to that particular article in the Criminal Code. Would Your Honour permit us time to consider that and reflect upon it? Obviously, we understand that the trial panel will wish detailed submissions in due course as to what we say is the definition of public interest to be applied.
We'd be grateful for that, Mr. Rees.
Thank you.
Thank you. And take on board as well my subsequent questions, if you may. I think you have clarified it, and I'm grateful for that, but I want to give Mr. Cadman also an opportunity to comment on something you said. Are we to understand that the public interest which you submit is relevant to these proceedings? In other words, the public interest that your clients were pursuing in conducting themselves in the way that the prosecution alleged they did was to expose what you said is the cooperation between the SITF and or the SPO on the one hand and the Serbian authorities on the other. That is the one and only, I should say, public interest that forms part of your case. Is that assumption a correct one? It hasn't been made practical for you, Mr. Rees. I do realize that.
I did try and move this earlier on. In short, Your Honour, I was agreeing that in order to be concise and to encapsulate the principle, the point, it can be summarised, the public interest can be summarised and has been in the defence pre-trial brief as the exposure of collaboration between the SPO and its predecessor and the Serbian authorities.
So let me press you a bit on that point. And again, if you feel that you need more time to address that issue in a different setting, please say so. But assuming that this would constitute a legitimate public interest for the purposes that you have identified, the prosecution, as I understand, is claiming that the collaboration between SITF on the one hand and SPO, on both of them, one or the other, and the Serbian authorities was in fact an issue that was and had been in the public domain for quite some time, and the material that they will seek to put on the record of these proceedings suggests that this was even an issue addressed by one or both of the defendants. So what I'm asking here, and again, offering you the possibility to stay your hand on your submission if you so wish, but would your position be that there was the public interest that you claim there was, despite the fact that this information, the cooperation between SITF/SPO and the Serbian authorities, was said to be in the public domain already at the relevant time?
We would certainly submit that information that is in the public interest does not lose its relevance because it's already been reported on previously. New information that is in the public interest can continue to be reported in the public interest, and it does not lose its status. For example, information that is in the public interest does not have that public interest only so long as it is a scoop. It cannot do.
I'm pressing onwards, Mr. Rees, and tell me when you wish to not be pressed further, but have you been able to determine what percentage or what amount of the material that the prosecution is relying upon to establish the charges would contain information that goes to that issue? In other words, what lies behind my question is how much of that material would go to that issue of public interest if we were to accept your submissions that demonstrating the cooperation that you mentioned would be in the public interest. Are you able to tell us what amount, percentage, quantity of the material that your clients are alleged to have unlawfully disclosed would reveal this sort of information or would go to establish that public interest?
No, I cannot assist with that because the prosecution has neither served the material as evidence nor have they disclosed it. So I cannot.
Well, they have to the extent that you have the supporting material, of course. You have 400 plus exhibit, but as you said, Mr., maybe my question was an unfair one, but keep it in mind.
Your Honour, I wish I could assist you on that. And we have sought disclosure from the very first hearing of that material so that we could precisely assist the trial panel with such issues as to the authenticity of the material, whether it is properly confidential, to precisely assist with issues as to which documents in particular go to the public interest and so on. But we have been refused disclosure accordingly. So I cannot.
Now, going back to the nature of this defense in the broader sense, I understand your position on the exact nature of what is being advanced is slightly different from your point of view than Mr. Cadman, and I totally accept this. But what I want to understand is whether you are disputing the fact that the SITF and or the SPO was authorized and in fact mandated to seek relevant information from all possible relevant sources of such information. Are you disputing this?
If I may answer the question this way, the trial panel will have to look in due course at the evidence to see exactly what was, for example, discussed and said in the press conferences, and look at the nature of that material. The nature of that material, the only names that were mentioned were publicly known names, people performing public roles in Serbia, each of whom had a particular history that made the disclosure of their collaboration with the SPO relevant and in the public interest. And we have set out at length in our defence pre-trial brief what we will say about those names. We will call evidence about them.
So, if I paraphrase and correct the paraphrasing, if you feel you have, the case of Mr. Gucati on the issue of public interest is therefore not one about generic cooperation between SITF on the one hand and SITF and SPO on the one hand and the Serbian authorities. On the other, your case on that point is the revealing of cooperation between, on the one hand, these two organizations, and on the other, a number of Serbian officials, which you have identified in your brief. Is that a fair understanding and summarizing of your case on that point?
Yes, as I accepted, Your Honour. To be concise, as a shorthand, reference to collaboration between the SPO and Serbian authorities is an accurate summary. But of course, at trial, the evidence that will be called will be more nuanced than that. And we have set out at length in our defence pre-trial brief, some 107 pages, clear indication of the facts that we intend to call. And the trial panel can take it that anything that we've put in the trial panel, in the pre-trial brief, any factual assertion therein, we propose to call evidence to support that factual assertion. That can be assumed by the trial panel.
Thank you, Mr. Rees. I will take it that the summary of your response was a yes to my question, but of course we will consider every factual matter that you put forward. You say in support of that, to the extent, of course, that they are relevant to the issues at stake, which is what we are endeavoring to establish today. Mr. Cadman, do you want to add anything to what has been said by your colleague?
Your Honour, due to the lateness of the hour, I don't think there's anything that I should reasonably add at this stage. Only just to support what Mr. Rees has said is that evidence will be called to that effect. And of course, it's whether both Mr. Gucati and Mr. Haradinaj had a reasonably held belief. I'd also take the point just very, very quickly about matters being in the public arena prior to the disclosures being made. We will, of course, be setting that out, and we certainly expect that to be part of the expert evidence. It is important to establish, in order for such a defence to succeed, is that it has been put into the public domain, and there have been attempts to address the issue that have not been successful, that have required steps to be taken. That is all part of the whistleblower defence, and certainly that's what's contained in, as we can set out in written submissions, in terms of what Kosovan law says as to whistleblowing and what the EU directive says as to whistleblowing. But of course, we can put that into written submissions, but our position is the fact that it's in the public domain does not undermine the defence. If anything, it enhances it.
Judge Barta had one question. I'm going to beg your indulgence for just a minute so that we can break as soon as possible. Go ahead.
Thank you, Mr. President. Very briefly, my question is actually for the defense. It seemed to me, I have to say, maybe I was wrong in this regard, that you are or were arguing that it was at least inappropriate, if not illegal, for the SPO to seek legal assistance and or cooperation of what you, Mr. Rees, called today collaboration from or with the Serbian authorities. So my question is, very briefly, are there any other legal avenues available to the defense, or excuse me, to the SPO, to the prosecution, than relying upon national authorities when inquiring about evidence located on their territory And if so, which legal avenues are there, in your opinion? Thanks. Sorry, I didn't mention that. Mr. Rees, if you want to take the floor, the floor is yours.
Well, it is a question that I would wish to consider and reflect upon the answer to, in short.
Mr. Catman?
I would adopt the same position.
Thank you. Any comment from the prosecution on this point?
Just very briefly, it is apparent from the materials disclosed and what is submitted in the bar table alone that not everything disclosed falls within the public interest identified. Of course, the SPO needs to be able to investigate using the cooperation framework provided by the law wherever evidence relevant to the investigation is. And all of this calls into question the public interest identified by the defense. We appreciate that they want to reflect and that the defense want to make further submissions. We will address them when they come.
Thank you.
All right, we'll take a 90-minute break. We'll try to catch, well, a little short of 90 minutes. We'll try to get back on schedule. So if you could be here at 2:30, we will have our last 1.5-hour session. And so we'll see you then.
All rise. All rise.
Now let's move on to the written observations on the draft order on the conduct of the proceedings. The panel thanks the SPO, the Haradinaj Defense, and the Registry for their submissions. Mr. Rees, you've indicated that you wish to make oral submissions instead. That was not envisaged by the order. Any specific reason you did not want to present a written order, a written response, I'm sorry?
It's my understanding of the order was that there was an invitation if you wanted to make written submissions,
Actually,
to do
we
it by the
ordered written
27th.
submissions, but it's not a problem. Would you like to have maybe till Friday to make a written submission?
Yes, if that is
I mean, I don't wanna-
if that is of more assistance to the trial panel,
Yeah.
then we'll do it that way. I'm grateful.
I think it would be simpler. We don't mean to punish you.
No.
We didn't understand, or maybe our order wasn't clear enough, but can you have something on file by
Yes,
Friday?
I'm sure.
Okay, all right, thank you very much.
Thank you. Your Honour, before we move on, this morning the question was asked as to whether there was authority for the proposition that a rogue agent would suffice when considering the plea of incitement. And I referred to the case of Ramanauskas. Ramanauskas is indeed the authority for that proposition. There are other cases, but it's there in Ramanauskas. In that case, the government of Lithuania explained that the officer who had approached a third person and offered a bribe had negotiated with him, as they put it, on his own private initiative, and had not informed the authorities of that action. And the European Court effectively said that the national authority couldn't be exempted from their responsibility for the action of their police officer by simply claiming that he was acting in a private capacity and hadn't discussed it with others first.
All right, thank you. In addition to the oral submissions that we received, the panel also has taken note of the registry submissions on services offered by WIPSO, the WPSO. In this regard, the panel has a question for the registry. What is the reason for the confidential classification of the registry practice directions attached to its submissions? And why aren't there any public redacted versions of these documents? Mr. Roach?
Thank you, Your Honour. The documents attached are in our administrative classification system, marked as limited, or limité, and this equates to confidential in the classification system used in legal workflow. This classification level is used for information and material in judicial support and administrative records, the unauthorised disclosure of which could be disadvantageous for a number of reasons, including the safety, security or privacy of any person, or the interest of justice, the parties or the participants to the proceedings. And a number of them refer to methodology, which is used by WIPSO in its engagement with witnesses and other persons it comes into contact with. And so the operational methodology used could be, for example, deduced and applied in future cases if persons wished to cause harm to a witness, for example, or other person engaged with the specialist chambers. If the panel so directs, we could review the documents. We have, I will admit, never considered whether there should be public redacted versions of these documents, but it is something that the registry would be very willing to consider if the panel so wished or directed.
I suppose our question is, because there are some practice directions that maybe privacy or safety are not involved, and perhaps those could be dealt with in a different way, just as a in the interest of transparency. So yes, maybe a review would be helpful, and you could perhaps report back to us at some point.
Thank you, Your Honour. We will do so.
Thank you. I will now render an oral order in relation to the registry submissions on the conduct of proceedings. The panel hereby orders the parties to indicate to the registry directly by the 6th of September 2021 their agreement, objections, or suggestions regarding the logistical arrangements accompanying initial contact, arrival, and familiarization of witnesses, which is in paragraphs 5 to 24 of the registry submissions. The registry is ordered to report back to the panel by 10 September 2021 on the outcome of these discussions, raising any unsolved matter. And that is the end of the oral order. So we'll move on now to translation and interpretation. In its 21 July order, the trial panel also instructed the parties to raise by the 3rd of September any remaining translation or interpretation-related concerns with the registry directly and to identify specifically the relevant passages of documents with which an issue is taken. The trial panel further ordered the SPO to seek verification of part of a transcript flagged by the Gucati defense as erroneously transcribed by 23 August of 2021. It also ordered the Gucati defense to submit by 27 August 2021 a filing containing the translation of the document relied upon in footnote 47 of its pretrial brief. I first give the floor to the registry to indicate any translation or interpretation related concerns raised by the parties pursuant to our order, and also to provide us an update on the state of the translations in the present case and whether there are any pending requests for translation. So, Mr. Roche, once again, you have the floor.
Thank you, Your Honour. To take your questions in order, since the order of the panel, no specific concerns have been raised by the parties regarding ongoing or outstanding translations. If you wish, I can give you an overview of the total number of translations since the pre-trial phase has commenced. I should point out that all filings and annexes are automatically transmitted by CMU to Language Services Unit for transmission, so that will include the documents which are required to be provided to the accused in translation, but also all other filings and annexes. So, Legal Services Unit or Language Services Unit has received 859 requests for translation since the commencement of the pre-trial phase, and of those, 426 are into Albanian, and the remainder are requests for translation into the Serbian language. We have completed translations of 90 of those documents, 68 of which are into Albanian, with the remainder into Serbian. And since the order of the panel on the 27th of July, there have, on the 21st of July, 122 requests have been received, 61 of which were into Albanian. And again, the high number reflects the fact that the submission of documents for translation is an automatic process. Thank you.
Thank you, Mr. Roach. As regards the verification of the transcript flagged by the Gucati defense, we note that the SPO disclosed on August 20th the results of this inquiry. Mr. Rees, I believe it was your objection or notation. Are you now satisfied as to the transcription and translation?
We haven't yet taken instructions.
Once again, your microphone.
We haven't yet taken instructions from Mr. Gucati on that matter. We will do so, and we will confirm to the SPO the position.
All right.
Thank you.
As regards the translation of the document relied upon in the Gucati pretrial brief, we note that a filing has been made in this regard. Mr. Prosecutor, any point to raise about the translation?
No submissions, Your Honor.
Thank you. Any other outstanding or unresolved translation or transcription issues? Any points to raise about the translations by anybody? Toby? No, Mr. Cadman, I'm sorry.
Your Honour, nothing specifically. We have raised throughout these proceedings that there, and we do understand the pressures that are on the registry and the translation service, but obviously it does cause difficulties to taking instructions from our clients who do not speak English and require to see everything in a language which they understand. From what Mr. Rocha said, the 400 or so translation of documents that need to be made, 90 of them have been done. I mean, that is obviously a very small selection of what has been sent for translation. We are finding ourselves in a position where we actually have to get rough translations done ourselves in order to be able to take instructions. The only point that we make, which we've made previously, is just to remind ourselves that this is an institution of the Republic of Kosovo. They are citizens of the Republic of Kosovo on trial. All documentation should be translated as far as possible in a language which they understand, and it does need to be accelerated. I understand, having worked in tribunals for some time, that translation is always one of the most pressing issues and one of the greatest use of resources, but we have to be mindful of the fact that Mr. Gucati and Mr. Haradinaj are entitled to be able to consider all of the material in a language which they understand.
Thank you, Mr. Kedman. Anything, Mr. Rees, anything you want to add?
No, thank you, Your
All
Honour.
right. Anything from the panel? Questions? The panel will issue an oral order in this regard at the end of the conference, which it looks like that will be tomorrow. We'll move on to the SBO list of witnesses. Judge Barta has indicated he had some questions concerning this, so we will give the floor to Judge Barta.
Thank you, Mr. President. First, the SPO list of witnesses. Mr. or Madam Prosecutor, do you in fact intend to continue with your plan of having 2 witnesses who are employed in your office as the sole witnesses in this trial?
No. The SPO is intending to call 1 additional witness. The statement of this witness is going to be disclosed this week. As will be seen upon disclosure, the statement is a more formal account of information provided to the defense. The defense have already been given advance notice, albeit just during the break before the last hearing, as to who the individual in question is. We will seek to file an application because we are aware that we need to seek the trial panel's leave to add this person to our list of witnesses. We will seek to file that application next week. And if you'd like more information about the individual in question, it would require a private session, but I'm available to do that as well.
There will be, I think you have seen, we are proposing perhaps the prosecution's preparation conference for next Wednesday. Can it be on file prior to that date?
Yes, Your Honor.
All right, thank you. Go ahead, Judge Barton.
Thank you. Just want to add that, let me at this juncture caution the SBO that the later requests for additional witnesses are made, the higher the threshold of good cause that the panel will adopt when determining such requests. I think this concludes my questions. Oh, no. Yeah, for the moment. Thank you.
The next topic concerns SPO witnesses and the panel's fact-finding responsibilities. I give the floor to Judge Metro, who has some questions on this topic. Judge Metro, you have the floor.
Thank you, Mr. President, and it's really more of a request than a question, I think. But at paragraph 19 of our order, we asked the SPO to explain to us how they intend to call the evidence of the 2 proposed witnesses without invading the province of the fact finders. And we pointed to a specific decision from the Milosevic case of 30 September 2002. And we directed you to the decision with a view to ensure that you do not seek to lead evidence from these witnesses that effectively would ask of them to draw conclusions or inferences that are within the remit or province of the trial panel. And the first thing that I would wish to hear from the SPO is whether that is clearly understood that this is the expectation of the panel in relation to these 2 witnesses.
It is, Your Honor. The SPO's witnesses are providing facts and evidence, not analysis and conclusions. Accordingly, there is no risk of them invading the fact finder's province. The batches at issue in this case contain confidential information on SITF SPO investigations and protected persons. They cannot be disclosed for reasons set out at length in the pretrial judge's decision authorizing their non-disclosure. Disclosing them is incompatible with the very premise upon which this case is brought, that such information should never have been disseminated in the first place. And the batches need not be disclosed because SPO staff can describe whether information seized belonged to the SPO and was confidentially classified. This is precisely what WO4841 intends to testify about. It is not possible, for example, whether information published in the media is contained within the batches without a witness from the SPO to link the media to the batches. WO4841 is necessary to provide such links as they are not apparent from the media articles alone. WO4842 is being called to testify, amongst other matters, on the scale of the resources that the SPO had to devote to addressing security concerns following the dissemination of the 3 batches. This is of direct relevance to Count 6, which is charged with a sentencing enhancement requiring proof that the protected persons whose information was revealed caused, quote, serious consequences for the person under protection, or the criminal proceedings are made impossible or severely hindered. WO4842 is able to speak to the hindrances to the SPO's investigation in a way which the documentary evidence alone cannot provide. These examples of their anticipated testimony illustrate how, unlike the Milosevic decision identified by the trial panel, WO4841 and WO4842 are not presented as mere analysts of the information and evidence before the trial panel, nor are they setting out opinions akin to expert witnesses. They will provide facts not available from the remainder of the case record, which are necessary to prove what is charged. As such, they do not encroach upon the fact-finding role of the trial panel. Thank you.
We take note of these submissions, Mr. Halling. The additional invitation that we'd make to you in light of the submissions you've just made is to ensure, as part of the examination in chief, that if they are asked about certain facts, that their basis or circumstances in which they came to have knowledge about one particular fact or circumstance that's relevant to the case is raised with them, so that it is clear at all stages the basis on which they are able to give information about this or that fact that you say is relevant to your case.
Understood.
Judge Gaynor, did you have a comment or a question, I mean?
Yes, I have some questions to follow.
Go ahead. You have the floor.
First of all, I'd like to ask the SPO about the submissions you've just made about the diversion that you argue has taken place of SPO resources. And you say that this diversion has severely hindered SPO investigations. The panel would like to better understand your arguments in this regard. Is it not the case that any investigation that the SPO carries out pursuant to its mandate will require diversion of resources towards that particular investigation? And if so, how does the SPO distinguish between investigations that amount to or involve unlawful obstruction of its work and those which do not?
Your Honor, the distinction that we would make is between the investigations that we're conducting within our core mandate and the extra investigation that's prompted going into issues like contempt, prompted by the criminal conduct of others. In this latter context, you can see it from the contact notes of witnesses. There is a lot of fear. There are a lot of struggles that they're having, and these people had to be systematically contacted on an office-wide level in a way that was never contemplated under the criminal investigation within the court's core mandate. It was extra, prompted by the conduct of the accused. And you can see from the official notes, and we can give examples if the trial panel would like, That the fear even extended so far as to even when witnesses were told that their names were not in the materials, that they still felt fear because of it. So all of this required management by the SPO, and in our submission, the totality of what needed to be done led to a substantial hindrance caused by the revelation of protected persons, which will not be true in normal investigative activity, but is true for this kind of investigative activity.
But is it not the case that investigating potential contempt of court is the job of any domestic prosecution service? It's not particularly distant from its core mandate.
It's a question of degree. I take the point from the trial panel that there will be some disruption to the normal order of operations whenever contempt occurs. But the relevant code provision for count 6 is talking about it with a qualifier. It's, severely hindered the investigation caused by this revelation. And not every investigation of contempt is going to cause that. But we believe that that element is met here on the evidence that we're presenting. It is a question of degree, and we think that that degree justifies the sentencing enhancement here.
Now, setting aside your arguments regarding the diversion of SPO resources, I want to ask you about count 2, which is obstruction by a group. Is the SPO case based on the argument that official persons, including SPO staff as well as judges, were in fact obstructed in performing their official duties? Or is the prosecution case based on the argument that the accused were aware that, as a result of participation in the group, this obstruction might ensue, and they acceded to the occurrence of this obstruction? Which of those two alternatives is the prosecution case based on?
There's lots of ways to describe criminal intentions. I will just use the ICTY terminology where you have general intent crimes, you can have indirect intent, sort of the accedance of the likelihood of result flowing from the criminal conduct being sufficient to establish liability. The element on count 2 that Your Honor is identifying has no specific intent in it, and so we would say that something more akin to indirect intent would meet the element. The only count that has a clear specific intention in it is count 4, if I'm not mistaken, and on retaliation. So the answer to your question would be the latter formulation of intent, that accepting a sufficiently strong possibility of a result is enough to incur responsibility under this count.
Okay, so in this particular case, you're not asserting, setting aside the diversion of resources argument, you're not asserting that any official was in fact obstructed in the performance of their duties. Is that correct?
I think that is correct, Your Honor, the way that you've described it. The second objective element, as identified in the confirmation decision, the first one is through participation in a group of persons which by common action, that's element 1. Element 2 is obstructs or attempts to obstruct an official person in performing official duties. The fact that attempt is embedded within the element is an indicator that the obstruction does not need to have occurred in order for criminal liability to ensue. So it is not a requirement to meet the elements of count 2 to prove the obstruction as such.
Thank you. Now, in respect of intimidation, is the panel correct in its understanding that the prosecution is not asserting that the accused induced or attempted to induce specific individual witnesses to refrain from making a statement or otherwise fail to state true information to the SPO?
The way I would understand the question, this is again a question of general intent. The conduct of the accused is intimidating. The accused do not need to know the specific individuals that they are intimidating or specifically intend that they are intimidating like one person as to opposed to another. If they engage in conduct that is intimidating within the meaning of the elements, then they would be convicted on the applicable law as set out in the confirmation decision. And just to foreshadow the submission from the chamber on this, we believe the pretrial judge is correct on the applicable law. So as understood, it would not be necessary to prove intimidation of specific persons. I hope that answers your question.
Right, that leads on very well to my next question. Could you confirm whether the SPO intends to prove that any specific witness felt intimidated, or that any specific witness felt that there had been acts of retaliation? Do you intend to prove that as part of your case?
Yes, as an evidentiary indicator of the intimidation and retaliatory intent. It is not an element of the offense, but the fact that people were intimidated or were retaliated against is an indicator, amongst all of the other evidence and all of the other factors, that the conduct itself was intimidating within the meaning for count 3, and that it was harmful action within the meaning of count 4. We understand these to be conduct crimes. We even have a footnote in discussing this, that it's, if you think of the construction of corruptly influencing a witness in the ICC statute under Article 71C, the jurisprudence of the ICC, and this goes to the Bemba et al. Appeals judgment that's in the list of authorities, doesn't require any particular consequence. The person need not have been corrupted. It's a conduct crime. However, the fact that someone was corrupted is an indicator that the corrupt influencing conduct occurred. And we're intending to do something similar here.
Can I ask you, or invite you, to explain briefly how you intend to prove that any specific witness felt a feeling of intimidation, or that a specific witness felt that there had been or were likely to be acts of retaliation? How do you propose to prove that?
This primarily relates to the contact notes that we have tendered through the bar table. So they are relevant to that factual indicator. They're also related to the other alternative in the sentencing enhancement, that the protected person suffered serious consequences. So we have collected all of this evidence. As we explain in the bar table request, it's not intended to be the sole or decisive evidence for any of the counts that we have charged, but it is relevant to the charges in this aspect.
Okay, we'll return to the question of contact notes, and I'll have some further questions on that in due course. But for the moment, that's all. Thank you.
Thank you, Judge Gaynor. The next topic concerns the SPO exhibit list. In the 21st July order, the panel indicated that it will seek submissions from the SPO on whether it intends to propose additions to its amended list of exhibits, and if so, the reasons for the delayed request.
Thank you, Your Honor. As indicated in the annex to the bar table request, and as recently discussed in the hearing, following the transcript review, we do have slightly altered, revised transcripts, and we do intend to have those on our list of exhibits, and we will make an application to that effect. Also, the additional witness that we mentioned, the disclosed statement, we would also seek to add to our list of exhibits. And the reason why is that we only required it recently. So that's going to be the reason for the request. But as I indicated on that respect, we're going to file a separate application next week before the Specialist Prosecutor Preparation Conference. So other than those things, there is no anticipated list of evidence addition we're contemplating.
And can your application be on file by the 6th of September so that we can actually see it before we hold the hearing?
Yes, Your Honor, on any timeline you like.
Okay. The panel will issue an order in that regard at the end of this conference. Any of my colleagues have any questions? Judge Metro?
Thank you, Judge Smith. Very briefly, and it's directed to the office, or to the SPO once again, simply to inquire whether you have taken the view that some of the items that are currently on your proposed exhibit lists, whether you have taken the view that you will not be relying upon any of these items, and if that is the case, whether you have given notice to the defense of your position.
Thank you, Your Honor. And just briefly before addressing it, I was reminded in our bar table annex, we also mentioned that we have a video on our list of exhibits, but the translation was not on the list of exhibits. And just for completeness, we've been doing this with other videos. That would be part of the same application. But turning to Your Honor's question, we are waiting for the trial panel's resolution of the bar table request that we've made in order to make any sort of definitive determination about what further exhibits are necessary on the list of exhibits. So as soon as that is resolved and there's clarity from our side as to what was admitted and what is not, we should be able to promptly give quite a precise notification as to what further exhibits will actually be tendered at trial.
We're grateful for the indication, and of course the question is intended to signify the panel's position that we do not condone the overloading of exhibit lists. We are not, of course, accusing you of having done that. We do think that it is helpful to the parties and to the process itself that if you have taken the view that any of your proposed exhibits are not to be used, that notification be given to the other side ASAP. And of course, the same logic would apply when we reach the defense case. So I'm grateful, Mr. Halling, for the indication. I have a couple more questions about some of the items that you have on your list presently. One of them, I can give you the numbers if that's useful to you. That's from 370 to 372 and 476 to 480. And those are in effect judgments of courts based in Kosovo. They are EULEX/UNMIC judgments. And the question is very much about the intended use of these document for the purpose of your case.
Yes, Your Honor. In order to establish the protected persons element for count 6 in particular, what protective measures have been given to the people in the batches is a subject that W04841 intends to testify about. And in order to preserve those protective measures, the cases in which these witnesses were protected needed to be notified to the defense at some level of abstraction. So citing to the judgments is our indicator as to what cases are going to be relevant in W4841's testimony. Now, that evidence may be elicited in a way that doesn't require the judgment itself to be in evidence. And at some level, we're in the trial panel's hands during the testimony of that witness, whether that's necessary. But that's why they're on the list of exhibits and what purpose they're serving.
So just so that I'm clear in my mind about the process that you will propose is the witness in question would come to court and assert that a person whose name was part of the disclosed information is the same person as was granted protective measures in one of these cases, and that means the panel will have to take that witness's word for it. Is that the process?
W04841 is going to indicate that a person in the batches also has protective measures in one of these other cases. In terms of taking the witness's word for it, it's up to the trial panel how to evaluate the testimony, whether additional evidence is required to establish the protected persons element. I would note in this regard that part of the protected persons element as identified by the pretrial judge is just being in these classified materials to begin with. So it may not be strictly speaking necessary to determine the protective measure status of individual witnesses in order to make a finding on count 6. So we would never say that the judges need to take our word for anything in the evidence record, but whether this, you asked what this evidence is intended for, this is what it's intended for.
Thank you. There's a second group of documents that form part of your exhibit list, And these are documents that refers not to the conduct or statements that you attribute to Mr. Haradinaj or Mr. Gucati, but to two other individuals in particular, a member of the Veterans Association and a legal advisor, whom you have mentioned in various filings. Now, what we want to understand from you is what purpose you will invite or what relevance you will invite the panel to attribute to these documents. Of course, I imagine your first submission will be that under one of your counts you will seek to establish that the offense was committed jointly. So put that particular aspect aside. Is there any other purposes that you seek to pursue by leading evidence pertaining to the acts of third parties who are not charged in these proceedings?
You correctly identified my initial submission, Your Honor. Going past that, the evidence of these other persons are often given in a way where it's clear that they are also speaking for the accused. There are examples, for instance, where the legal advisor is speaking in an interview with one or both of the accused. You also have an example where the other gentleman you mentioned gave an interview, making many of the same talking points as the accused, and was congratulated by Mr. Haradinaj on Facebook. So there are certain statements of these other persons that are revealing of the intentions of the accused. And to that extent, it is also relevant to prove the mens rea for actually all the counts.
I'm grateful. You will, of course, be mindful, I'm sure, of the fact that there are certain human rights implications and limitations to the findings that can be sought of the panel in respect of individuals who are not subject to these proceedings and who are to be presumed innocent, of course, and will be treated as such and do not have the benefit of a defense. So I'm just giving you that indication for you to take into consideration in the way you will attempt to present that evidence. Lastly, Exhibit 33, I think it is, on your list, which is the document in relation to which we had a discussion a moment ago, where a new transcription and translation has been given. Is that your plan to apply to us to have that new version, subject, of course, to what Mr. Rees might be able to give you as an indication, to have that new translation and transcription to replace the old one?
That's correct, Your Honor. And as indicated, there is a footnote in our bar table request annex that confirms that the exhibit tendered for admission is indeed the revised transcript for this particular item.
And finally, a number of these proposed exhibits contained redactions, sometimes very heavy redactions. Are you intent on tendering those versions of the document, that is those that were communicated as part of the disclosure process to the defense, or are you intent on tendering less redacted or differently redacted versions of these same documents?
We are tendering the redacted version that has been disclosed to the defense. We are not going to rely on anything that is covered by those redactions because the defense cannot fairly respond to it. In terms of whether the level of redactions could be revisited or there could be lesser redacted versions, the jurisprudence requires the SPO to keep this under review throughout the trial. When we see an opportunity to file a lesser redacted version of something tendered for admission, then we will do so. If the trial panel is interested in prompting us to do so in relation to a particular item, it's of course within the judge's prerogative. But at this time, what we are tendering are the redacted versions that have been disclosed, and we are only relying on the contents that can be seen.
Any question or comment from the defense? Of course, Mr. Cadman, we have taken note of your earlier comments about difficulties associated, you say, with some of these redactions, but putting that issue aside, anything else that you would wish to respond to?
Not at this stage, Your Honour. There have been a number of things set out by the SPO that will require us to consider our position but we will certainly come back, so we'll reserve our position for now.
Thank you. Mr. Rees?
We will, of course, consider the bar table motion that's been made by the SBO and respond to that in due course. I think many of these issues will be dealt with in our response to that application.
Thank you.
My colleagues have no other questions, so we will move on to the next topic on the agenda, which concerns the right to confrontation. And Judge Barta will lead that discussion at this point. Go ahead.
Thank you, Mr. President. In the 21st July order, the panel indicated that it will seek oral submissions on how the SBO intends to guarantee the effectiveness of the right of confrontation as provided under Article 6, Paragraph 3, letter D of the European Convention on Human Rights, and reflected in Article 31, Paragraph 4 of the Constitution of Kosovo, Article 21, Paragraph 4, letter F of the law of the Kosovo Specialist Chambers, and Rules 153 to 155 in respect of proposed exhibits, where A, the author of the proposed exhibit is known to the defense but is not called to give evidence. B, the author of the proposed exhibit is unknown to the defense because identifying information has been redacted. And or C, the proposed exhibit is a record of what a third party has stated, and that third party is not called to give evidence. Furthermore, submissions were sought on A, whether the SPO can confirm that the author of the proposed exhibit or the third party whose statement is recorded is unable to testify, and if so, whether the reason is within the meaning of Rule 155 of the KC rules, and B, whether the SPO intends to tender into evidence any of the SPO official notes concerning contact with the witness, and if so, under what provision of the rules. Meanwhile, the SPO has already submitted a request for admission through the bar table, so the last question has been answered. For the others, Mr. Prosecutor, you have the floor.
Thank you, Your Honor. To discuss this question and the subparts within it, it is important to underscore from the outset that the core of the evidence in this case is publicly available video and publicly available statements of the accused. All the elements of the offenses charged can be made out on those videos and statements alone. Confrontation of SPO official notes must be understood in this light. Focusing on SPO official investigative notes in particular, it is standard in criminal trials for an investigator to summarize the prosecution's investigation and evidence. This is what W04841 will be doing in this case. Calling every single investigator who participated in a large investigation is simply unnecessary when they are describing the investigative activities they undertake pursuant to their official duties. What people say to them in the course of those duties may implicate questions of admissibility, but 1, no witness statements were taken during these operations. 2, the purpose of them was not to take testimonial evidence. 3, for reasons explained in the bar table request, statements of the accused do not implicate the right to confrontation the same way witnesses do. And 4, what statements are recorded in these investigative reports are fully consistent with what the accused say in the course of their public statements. The categories identified by the trial panel are all variations of the same question, all of which concern admitting materials without a corresponding witness. There's a distinction, as we discuss in our bar table request, between what human rights law requires and what the statutory admissibility framework, such as Rules 153 to 155, require. A further distinction must be made between the admissibility of evidence and the weight ascribed to that evidence at the end of the proceedings. As discussed in the bar table request, human rights law permits reliance upon absent or anonymous witnesses, extending the term witness also to persons not being called. The European Court of Human Rights sets out factors summarized by the SPO and also the Haradinaj defense in recent filings. The key consideration regarding this test is that it is really a test of weight rather than admissibility. The trial panel must be mindful of the rights of the accused when weighing the evidence at the end of trial, but there's no admissibility restriction imposed by the European Court of Human Rights on such materials. As for admissibility in the KSE statutory scheme, the trial panel is given substantial discretion in this regard. Rules 153 to 155, as we've discussed earlier today, require the evidence to be testimonial and to be taken in the context of legal proceedings. For the reasons explained in our bar table request, none of the evidence tendered for admission implicates these concerns. There is no reason to consider that the defense will not have an adequate right to confrontation in this trial. The heart of the prosecution's evidence in this case is not witnesses, but rather open source audiovisual evidence. The elements of the offense are established by what the accused did on video for all to see. No redactions or questions of provenance implicated. The defense objections about confronting an anonymous case are all predicated on misrepresenting the SPO's case, focusing on a subset of the evidence which is never intended to be the sole or decisive evidence for any element of the offenses charged. Now, there was another part of your question on the agenda related to contact notes in Rule 155. Would you like me to address that now as well? None of the evidence tendered without a witness falls under these rules, including 155. And in this regard, you can see our bar table request and the Ongwen case site and the ICTY authorities that circumscribe the interpretation of these rules to testimonial evidence in the context of legal proceedings. So Rule 155 does not apply in our submission to these contact notes in particular. If it was assumed, for sake of argument, that Rule 155 did apply to these contact notes, I would just note that the criteria would be met. It is noted that Rule 155 is broader than comparable rules at other tribunals, such as Rule 68(2)(c) of the ICC Rules of Procedure and Evidence. Rule 155 extends unavailability to a person who has died, who can no longer be traced with reasonable diligence, or who is by reason of physical or mental impairment or other compelling reason unable to testify orally. Compelling reasons are present here. A finding has been made by the pretrial judge that non-disclosure of the persons concerned by these contact notes is strictly necessary. This is fully supported by the information disclosed, particularly by those who said they suffered serious psychological harms as a result of the disclosures. When combining the pretrial judge's determination with the secondary role these notes play in the cases charged, it would be perfectly appropriate to admit this evidence under Rule 155 were it to apply. Thank you.
Thank you, Mr. Prosecutor. Does the defense want to comment on these submissions? Mr. Rees?
We will raise our objections in the written submissions in reply to the bar table motion.
Very well. Mr. Cadman?
Likewise, Your Honour.
Thank you.
Judge Metro, I believe you had some questions.
Thank you, Mr. President. I do, and I want to press you a little bit, Mr. Halling. You're getting used to being pressed on that issue, and I will come in a second to Rule 155 that you've just cited. But let me start with this. Let's assume that you bring your witnesses in court and you ask them, as you seem to be intending, to comment upon some of these notes. Is that the case that they and we will effectively be put in a position of them having to assume, of course, that the information that's contained in these notes is complete, accurate, and that the translation, of course, that might have taken place in that context was reliable. In other words, the witness will be asked or would be asked to assume that whatever is contained in this note is indeed correct and a correct, accurate reflection of the exchange that might have taken place between a witness and one of your staff.
Yes, Your Honor. This is within the scope of WO4842's testimony, and the answers to that question will be before the trial panel viva voce.
Then the follow-up question is how do you say the defense would be in a position to effectively, and I use the technical term of effective confrontation under the ECHR regime, to effectively challenge the accuracy of that record if the note in question, in particular, was not drawn up by your witness?
The witness in question, because they were involved in writing these notes, is able to speak generally to the process by which such notes are made at the SPO. The defense is given all of the content of the contact notes that is being relied upon. They can contest their contents, including and they've already been doing this in submissions, the dates on which they appear or the way in which the information is presented. They are entitled to do that. In their bar table responses, we expect them to do it again. So they are given an opportunity to challenge the statements. And at least according to the European Court of Human Rights, there is nothing necessarily prohibiting reliance on such statements, particularly as a question of admissibility, if they aren't able to examine each and every person in those contact notes.
Well, what you are saying, and again, I don't mean to put words in your mouth, but you are suggesting that they would be able to ask questions of the witness about the general procedure by which, or the manner, the process by which these notes are taken. But I'm more curious to know about the process in relation to a specific note that might have been prepared and that they would want to challenge the reliability, the credibility, the accuracy of the record, as the defense appears to be doing in their submissions. How do you suggest that they would be able to effectively do so in relation not to the general procedure that's being followed by your office, we understand that, but in relation to a specific note that you seek to rely on? And I remind you that in your own submission, and you've repeated it now, you are also relying on that material to establish what you say is the intimidating nature of the conduct you attribute to the defendants.
Yes, Your Honor. WO4842 did draft some of these notes himself, and he's able to speak to those notes and is able to answer every question that's contemplated in Your Honor's question. All other notes are going to look the same. They are going to have similar processes, and the reliability of them is going to be mutually reinforced by what WO4842 is in a position to say in relation to his notes. We are not going to call, just like it's a mirror image of the investigation question, we are not going to call every single person that contacted one of these witnesses. In our submission, it's not necessary for us to discharge our burden of proof to do so. But this is ultimately a question of weight going to the trial panel. If the trial panel is concerned about the reliability of exhibits beyond those that the witness can speak to directly, this will be reflected in the judgment, I'm quite sure. But it's not a question of their admissibility, and it's not a question of confrontation. They are going to get a right to confront the evidence. The question then becomes, what are fair uses of that evidence at the end of the trial?
If there is any concern to add, Mr. Halling, it should be yours. We are not concerned by anything on this side of the courtroom. Going to Rule 155, on which you are, or that you have made mention of, suggesting that if the rules that you rely on do not provide a basis, Rule 155 would provide you that basis. Now, the rule as I read them say that, or other compelling reason the individual concerned is unable to testify orally. Now, there's an inability that has to be established for this rule to kick in. My question is whether you have inquired with any of the persons concerned, whether they are the author of other notes or the individual, the witnesses to whom they spoke, whether they would be prepared to testify, and whether you have received an indication by some or all of them that they are, as the rules say, unable to testify orally. In other words, that they have refused or expressed their unwillingness to be called as witnesses? Or is it simply the case that it is your judgment that this should not be the case?
I understand Your Honor's question to be in relation to the persons contacted. If I've misunderstood the question, please correct me.
Well, take it to both. The complaint, as I understand it from the defense, is that there's effectively a multiplication of the hurdles that they are facing. The fact that there's a hurdle in their mind about the protective measures that are being sought from the witness, to which is added a hurdle in terms of both publicity and ability to confront, in the fact that the person who drew up the note is not identified, and you've mentioned, with the exception of 3 or 4 notes that were prepared by one of your proposed witnesses, to which there's an added layer of difficulty, they say, which is the fact that the identity of the individual at the other side of the telephone line is again not identified. So my question is to you is whether any steps have been taken by your office to query with any of these persons, be they the author of these notes, or, and perhaps more relevantly, you are right, the persons who were at the other side of the phone call, the witnesses, whether any of them have been asked to give evidence and have declined to do so.
As concerns the SPO staff taking the notes, that isn't the Rule 155 submission that we are making. We have no indication that the SPO staff in question are unavailable within the meaning of the rule. The statements in the notes that are of interest are not them. They are just sort of the vehicle by which the statements of these other persons come. And that is what the Rule 155 submission is focusing on. It's a singular collection of evidence in the sense that part of the answer to Your Honor's question is embedded in the evidence itself. The difficulties that the witnesses face in coming to testify and the compelling reasons are in the notes themselves. And as to the question of sort of taking the SPO's word for it as to whether or not they could come, this isn't our word for it. We made an application to the pretrial judge that their non-disclosure was strictly necessary. And the pretrial judge granted that application, which is why these redactions have been applied in the first place.
But
so,
I'll stop you there, Mr. Hadding. This is, with all due respect, 2 different questions. At best, the notes that you are seeking to tender do indeed reflect the expression of a concern by any of these or some of these individuals. This is not the issue I was going to. My question, and I will repeat it, is whether any of these persons was asked to testify by your office and that they declined to do so. I would assume that if this had been done and there were those security concerns, the proper course of action is to seek protective measures from the chamber. So back to my question, was any of these persons contacted for the purpose of giving evidence?
I think I'm stating it correctly that once we got the ruling of the pretrial judge that we did not need to disclose their names, we did not have any further discussions about which ones should be on our witness list because it was never our position that they would be. And this goes back to the original submission. All of this discussion, in our view, is on the hypothetical understanding that Rule 155 applies. Our position is that it doesn't apply, and our decisions in terms of consulting witnesses with a view of their testimony need to be understood in that light. We don't think of these people as our witnesses making witness statements.
Thank you.
Thank you, Mr. President. I do have a few questions for the SPO. Mr. Howling, do you accept that for the purposes of Rules 153 to 155, a written statement includes any record prepared for the purpose of legal proceedings of questions to and answers from a witness.
Not everyone. There are certain situations where, and you see it in the notes, if a witness is asked about their security concerns, for instance, there will necessarily be a question and answer in order to determine whether those security concerns exist. But looking at the authorities we provide in our bar table request, that is not necessarily making it within the context of legal proceedings. An interview by a journalist is another example. That would also be a situation where you would have a question and answer, but it wouldn't be a statement within the meaning of these rules. The legal proceedings, these are not people who are on our witness list. They're not people we're intending to call. They are not questioned about their knowledge of any particular case. They are asked about how they felt. They're asked about their state of mind as a result of these disclosures. And so we weren't interviewing them. And so not every, although there's a question and answer inevitable in any phone call talking to a witness about these topics, it doesn't necessarily bring it within the scope of the rules.
Very well. In your bar table motion, you suggest that some of these notes are to be admitted if your motion is granted to establish, quote, the serious consequences witnesses suffered as a result of the acts and conduct of the accused, unquote. And earlier you said that you will be tendering this evidence in order to establish feelings of intimidation felt by witnesses or feelings that retaliation might be in the air or might have taken place. Do you accept that any note which establishes that kind of information is a witness statement for the purpose of Rules 153, 154, 155?
We do not. Legal proceedings, as was discussed earlier, we understand it as a term of art. The whole context of this conversation depends on a latent understanding that something that might be a statement is going to be used in evidence in legal proceedings. So if the definition of legal proceedings was extended to anything that is relied upon in evidence in a criminal case, then the limits of the rules would have no meaning. Everything would become relevant for legal proceedings because it's being tendered in the first place for legal proceedings. It's something about the content of the statement, its characteristics, and the way it was initially collected that in our submission is what these cases are focusing on, which is why you see instances like the one in Ongwen that we cite to in our bar table request, whereby a witness's statement containing information was found to fall within the Rule 153 analog of the ICC rules. But an investigator report by that same witness, even referencing some of the same information, was found not to fall within the scope of the rules. The difference is one was testimonial in a way that the other wasn't. And you can see similar distinctions with the legal proceedings, not legal proceedings. And in this example, maybe the most applicable in our bar table request is the Lubanga example, where it was actually the defense who were tendering security contacts of prosecution witnesses. The prosecution objected on internal work product grounds and that it was testimonial, covered by, they weren't able to admit it through the bar table, and the Lubanga trial chamber accepted it. Not everything with a question and answer component is necessarily legal proceedings, and as we've discussed, because of the similarity of these rules to ones at other tribunals, we think that reliance should be placed on the way that they have interpreted the scope of the provisions.
Okay, now, the Lubanga decision that you cited, I think you accepted in your motion that that decision came down well before the rules of procedure and evidence of the ICC were incorporated to include the lessons of Rule 92 bis ter quater at the ICTY. Is that not the case?
That's correct. In our submission, that actually makes it even more applicable because there was a Rule 68 at the time of the Lubanga decision. It was a simpler version of the rule that only had what, if I recall, they had Rule 68.2a and Rule 68.3 of the modern rule, which meant that the kinds of things that needed to be introduced for a witness were narrower. The principle of orality, in other words, was stronger at the time of Lubanga than it is now. So for the Lubanga trial chamber to say, in the face of that stronger principle of orality that had fewer exceptions back then, that it still could be tendered without a witness, we find to be meaningful.
I have a few questions about the distinction between the act of phoning a witness and the creation of a contact note of the conversation, which is reflected in that note. Now, the accused in this case were arrested on the 25th of September 2020, I believe. Some of the SPO contact notes appear to have been prepared by SPO staff in January and February of 2021 regarding conversations with witnesses that had taken place in September or October of 2020. Now, the SPO sought their admission and evidence yesterday, just over 6 months after the notes were prepared. Now, you appear to have stated in your submissions that these notes, that is to say, the conversations with the witnesses, were not taken for the purpose of legal proceedings. However, my question is, were the notes prepared by your staff in January and February of 2021? Were they not prepared for the purpose of legal proceedings?
Apologies, Your Honor. Just give me a moment. I want to pull up the decision that's relevant to your answers to Your Honor's question. Yes. Thank you. Sorry. These notes, the delay in them, you can see from the notes themselves that they were taken at a much earlier point, many of the notes that have these January dates on them, and that they were actually reflecting often September 2020 conversations at a later point. As of January 2022, the overwhelming majority of these notes, anything unrelated to WO4842, in fact, it was not our intention to disclose and rely upon those notes in these legal proceedings. You can see it from their absence in our in-depth analysis chart, our Rule 86.3 outline. We weren't relying on these notes. And you can see it from the moment when they were disclosed. They were largely disclosed as a result of a counterbalancing measure ordered by the pretrial judge in Decision 136 that was rendered on, I believe, 22 February 2021. So that was the first indication to us that we needed to disclose these additional materials. As has happened with other counterbalancing measures ordered by the pretrial judge, once the bridge was crossed to have to disclose the material, because it is relevant to our charges, we decided then to rely on it. So the procedural history of these notes is consistent with what I'm saying. They were not prepared for legal proceedings. They were brought into them, and now we are seeking to rely upon them.
You are indeed seeking to rely upon them. And as we've mentioned, you're seeking to rely on them in part to establish the serious consequences witnesses suffered as a result of the acts and conduct of the accused, to use the formulation set out in the appendix to your bar table motion. But is it not the case that in doing so, in asking the panel to accept these notes as proof of serious consequences, of proof of feelings of intimidation, of proof of a sense that perhaps intimidation was in the air, are you not asking the panel to accept the truth of the information provided by those witnesses to the SPO?
We are, but the element that you're describing and where it's placed in our case, I wanted to emphasize. The serious consequences is not an element of any of the offenses. It's an element of the sentencing enhancement on count 6 alone. And sentencing in the KSC statutory scheme has a different procedural framework and different confrontation rights than the evidence at trial. It's actually presumptively a written procedure. If you look at Rule 162, of the KSC rules. So there may be a situation to forecast where the trial panel uses these notes only when corroborated by other factors in the trial judgment for the elements of the offenses, and may use them for more at sentencing in a way that's perfectly in conformity with the statutory framework. The defense doesn't have the same right to examine sentencing witnesses as they do when examining the witnesses during trial, and the way in which the KSC statutory scheme is phrased, it is generally not a bifurcated sentencing procedure. So we need to present all evidence establishing these serious consequences now. And this goes back to the distinction I was making at the beginning of my submissions. There's a difference between admissibility and weight. And if the trial panel has reservations about using these in the conviction stage versus the sentencing stage, it's within the prerogative of the trial panel. But as a question of admissibility, they're allowed to enter the discussion. They're allowed to enter the deliberations of the trial panel, and then the weight ascribed to them would be at the end of the trial.
Thank you. I believe that's all the questions that I have on this subject. Thank you, Judge Smith.
Thank you, Mr. President. Indeed, I have a question, another one, very briefly, for the prosecution. Again, unfortunately. Mr. Prosecutor, you argued a couple of minutes ago and also in your bar table motion that rules 153 to 155 are not applicable in the present case, and of course you gave reasons for this view. I don't have to summarize these reasons, I don't want. In case, Mr. Prosecutor, that the panel does not share your reasoning, which of the aforementioned, this is my question, 3 rules would be applicable in our case, given that the contact notes contain information on the potential, inter alia, I have to say, on the potential consequences of the alleged conduct of the accused? Would this refer, in your opinion, to the acts and conduct of an accused within the meaning of Rule 154, or would Rule 153 be applicable? Thank you.
Yes, I understand Your Honor's question is a different version of what we were calling the hypothetical situation with Rule 155. Rule 154, acts and conduct, is actually not a prohibition to introduction through that rule. Obviously, we aren't intending to call any of these people at this time. I think we've been quite clear. So we aren't intending to use, we're not thinking in a Rule 154 lens with these persons. As regards Rule 153, and we can provide authorities if the court is interested in this, acts and conduct of the accused is generally understood within the kind of natural meaning of those terms. It is the acts of the accused and their conduct. These witnesses actually have no knowledge of the acts and conduct of the accused themselves. They are describing the impact of those actions upon them. And if you look at Rule 153, were it to apply, one of the factors in favor of admissibility under that rule is the impact of the crimes upon the victims. So if Rule 153 applied, we would argue that it actually, that part of the rule wouldn't be the issue. It goes back to the original question about whether these fall within the scope of the rules at all, and we've stated our position, but that's how I would respond to your additional question.
Thank you, Mr. Prosecutor. Any comments from the defense on this?
I had a question first.
Oh,
Mr.
sorry.
Helling, am I correct? Do I remember that at the very beginning you said the public statements made your case out completely?
That's correct, Your Honor.
And so this evidence that we've been talking about now for 45 minutes is somewhat irrelevant to your case, correct? That's what I think I've heard you say.
I hope I didn't say that.
Well, it sounded that way.
Our submission is not that the evidence is irrelevant. Our submission is that the evidence is relevant and is probative, but it is not anticipated of being the sole or decisive factor in proving any of the elements of the offense.
I think you said it might be possible you'll only use it at the sentencing stage, if there were a bifurcated sentencing stage.
Yes, we are presenting it to prove the elements of the offenses. We talked about it being an indicator of the intimidating and retaliatory conduct, but we are presenting it also for sentencing.
And
So
you didn't plan on using it at the beginning when you charged these people?
we did not, Your Honor. You can see it from the initial proceedings. We were initially planning on relying on W04842, and it was the pretrial judge's decision that prompted us to add this material.
Okay, we're not bound by that, you know. And if I follow these people's suggestion to my left and throw this evidence out, it doesn't really affect your case any, correct? Except for the sentencing stage, possibly.
I would hope that would be the result, but it's actually up to the trial panel to decide what the importance of this evidence is at the end of the proceedings.
Well, I'm just trying to find out why it is so important, since you think your case is proven entirely by the public statements. I mean, isn't that sort of one of the definitions of irrelevant?
Yeah, I would say no.
Okay.
The way in which we've proven the case, although the trial panel could rely on that alone, we don't know what the trial panel is actually going to rely upon.
Oh, well, we'll tell you pretty soon.
I have no doubt of it. But what is relevant is whether or not it goes to a fact and issue. And as we've been discussing, it goes towards the elements of the offenses, and it particularly goes to the elements of the sentencing enhancement, but it even goes to the elements of the offenses as charged. Whether it ends up being that the public statements alone are sufficient is a question for the trial judgment. From our side, we aren't able to know that, and so we're tendering evidence that is prima facie relevant and probative for your further consideration.
I appreciate a nicely stated argument, so I can't say I necessarily agree with all of that, but thank you very much.
We will deal in detail with these matters in our written reply to the bar table motion. I will just mention one thing, though. The trial panel should be aware that at the very first status conference in January, the SPO did inform the court that they were subject to steps being taken intending to interview and call evidence from up to 10 additional witnesses. Certainly at the time, I think it was all parties and the court's understanding that that referred to people who the SPO would allege had suffered consequences from the conduct relating to the charges. And that was on the 8th of January. The trial panel can see that from the transcript and also the prosecution's submissions for the first status conference in writing.
Anything else from any of my colleagues? Okay. So we've got about 13 minutes left. We'll start with the next subject, hopefully finish it. Judge Gaynor has asked to ask a question on the topic concerning the authenticity of the SPO exhibits. Judge Gaynor.
Thank you, Mr. President. In the order of 21st of July of this year, the panel took note of the challenge of the Gucati defence as indicated in its pretrial brief as to the authenticity of the documents delivered to the Veterans Association on the 7th and 16th September 2020. And in that order, the panel invited the Gucati defence to specify whether it submits that the material allegedly disclosed by the accused did not form part of the SITF SPO records, or that it was fabricated, or that no adequate chain of custody has been provided by the SPO, or that the authenticity of the material is being disputed under another basis. First of all, I'll invite Mr. Rees to take the floor.
Firstly, the challenge to the authenticity of documents is not limited to those documents delivered on the 7th and the 16th of September. but it also extends the documents delivered on the 22nd of September, as is spelled out in the defence pre-trial brief at paragraphs 278 and paragraph 300. The position taken in the defence pre-trial brief is that the accused did not know whether the documents and any markings purporting to indicate confidentiality and or internal work product were authentic or false. The accused did not know that. Accordingly, the accused's position is to be understood as requiring the prosecution to prove the authenticity of the material delivered on the 7th, the 16th, and the 22nd of September. I adopt on behalf of Mr. Gucati all three of the positions that are articulated in paragraph 23 of the order. Firstly, it is not accepted that the material allegedly disclosed by the accused in whole or in part formed part of the SITF SPO records. B, we do not accept that it was not in whole or in part fabricated. And C, we do not accept that any adequate chain of custody has been provided by the SPO. Indeed, we adopt all three of those positions, or any combination thereof, because as the defence pre-trial brief sets out, Mr. Gucati, the accused, did not know whether the documents and any markings purporting to indicate confidentiality and or internal work product were authentic or were false.
Thank you, Mr. Cadman. I'll invite you to address us on this issue.
Thank you, Your Honour. The position is the same. We have set out from the very beginning of these proceedings that we are not in a position to be able to authenticate that material, both in terms of it being authentic documents from the SPO SITF, nor are we able to say whether the material that the SPO now rely upon is that material that was seized from the premises of our respective clients. We have not been able to scrutinise that material. The pre-trial judge wasn't able to scrutinise that material, and as I understand it today, neither will Your Honours be able to scrutinise that material to make that determination. No witness has been called who was present, as far as we understand, on those three occasions where the documents were seized. No chain of custody is being presented that would be able to establish those documents as being authentic and the same documents that were allegedly seized on those three occasions. So we maintain that position, and the prosecution has to be put to strict proof to establish that.
Thank you. I'd now like to invite the prosecution to respond.
Thank you, Your Honour. The SPO has the burden to prove that the documents distributed concern SPO investigations and are confidential. We intend to prove this by 1, calling the investigator who compared the materials in detail, 2, presenting evidence on the various indicia on the documents that the investigator identifies, which proves whose documents these are and what their classification is, 3, the media articles which reveal pages of these batches, which can be seen and scrutinized by the trial panel, and 4, last but not least, the behavior of the accused, whose every word and action is consistent with them knowing that these documents were secret and concerned SPO investigations. As to the 16 September 2020 documents in particular, known as Batch 2, the SPO has also disclosed this batch with redactions and will tender it through W04841. This disclosure was possible, incidentally, because most of the information in this batch was publicly available. The defense can challenge the authenticity of these materials as they wish. The Gucati defense, turning to the media article point that I was making, they put great emphasis on the fact that the pages published by the media could have come from some source other than the KLA War Veterans Association. And again, I've said it earlier, I'm committing to it again. The elements of the offenses charged are proven by the video recorded conduct of the accused alone. That the media further disseminated the materials after the accused merely bolsters what the accused did in the first place. Where the media got what they published is a question of inference to be ultimately considered at the end of the trial, but it suffices for now to say at least one media outlet does confirm that it received the materials in question from the KLA War Veterans Association, that the media articles on this information are all clustered immediately after press conferences where the accused purported to release those same materials to the media, that this same pattern happened on multiple occasions, and last but not least, there's no evidence of any source other than the KLA War Veterans Association delivering these same materials to the media. So in short, Your Honors, we are aware that we need to prove the authenticity of these documents, and we fully intend to do so.
And just to clarify, in respect of the third batch, which I understand will not be provided to the panel, does it form any part whatsoever of your case?
It does, Your Honor. It's one of the 3 disclosures, and the list of indicators that I gave above will be true for batch 3 as well. W04841 will talk about what is in the batch. You will have the declaration before you analyzing it that also has excerpts of the confidentiality seals. And then the media articles that have pictures of that batch will also be discussed in the manner that I described.
But the panel will not be able to inspect for itself the contents of batch 3, is that correct?
That's correct. And this goes to the earlier submission that we made. We can't disclose these batches. We consider them to be our internal work product, which the rules say we are allowed to keep and not disclose even to the chamber. But the other, in our submission, we don't need the batch in order to prove the case. We've built the case without it, and we fully expect to provide sufficient evidence for the trial panel to be able to fairly reach the conviction that we are seeking.
I have no further questions on this subject. Judge Smith, thank you.
I believe we will adjourn for today rather than trying to start up another subject. Vicky has something for me. Want me to wait? We have a short pause for the interpreters. Before we break, by the way, first of all, we will meet again tomorrow at 9:30, as I said earlier. I would like to inform you that the panel will set aside some time during tomorrow's hearing to hear the SBO's arguments regarding the redactions for the Rule 1023 detailed notice. We expect this to be an inter-party hearing. If now or during the hearing the SBO believes that some information cannot be shared with the defense, the SBO can request the panel to have an additional ex parte hearing. Prior to the hearing, the SBO is expected to give fair notice to the defense about the nature and extent of their objections to disclosure. That ends our procedure for today. We thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. So we will see you tomorrow at 9:30.
All rise.
Meeting is adjourned.